Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Write you with the facts, pretty brown girl with the sass. Morelia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Good morning, good morning, good morning, good afternoon, whatever it may be. Yes, we have. I figured I would make a banner because a little, you know, I had the little, so that is not anybody's actual picture, guys. It's just that I was like, every time that they walk in or something, I didn't want to have to keep saying it. So yes, let's start off the day with wishing them both a very happy birthday. I don't even know if either one of them have entered the chat. They may be out here twerking. Well, I won't say Jason twerking. Jason is not allowed to twerk. Jason, if you out there twerking, then we have a whole problem. You need to approach. But Leah, on the other hand, yeah, we got a whole bunch of Aries birthday. I couldn't believe that it was like 2 on the same day. So happy birthday. I hope both of them are enjoying their day. So as we see them enter the chat, we can send our happy birthdays out. Good morning, lady. Hey, SD. Hey, Christine. Hey, Just Shamrock. How are you? You going on vacation next week? Where you going, Christine? Can you take me? I want to go. I want to go. I want to go on vacation too. Wow. Hey, Film, good morning. Oh, you coming down here where I'm at? Christine, that's where I'm at. I'm in Phoenix, Arizona. Well, not in Phoenix, Arizona, but I'm about 45 minutes away from Phoenix, Arizona. Oh, awesome. It's hot. I guess you don't have to pack me up and take you with you because I'm already here. I am already here. Yes, yes, yes. You got that right. So, guys, we are in day 4 of our Tremaine Jones trial. So far, we have heard from many and plenty witnesses. Remember, they said they had 150 witnesses that were going to be taking the stand. We have heard from the 2 women that were fighting, that wanted to fight over Tremaine's D, right? And then we had the baby daddy who's not the baby daddy. Then we had the stalker who became a snitch and told everything. He followed Tremaine around the entire night. He even told Tremaine, hey, don't go back and get your boot bag because the cops are over there. And hey, that wasn't just a random person that you pew. That was a cop. He actually got on the stand and identified that. So, interesting. Interesting. So now we are at day 4. Yesterday we left off with the detective that was doing the ballistics. We have heard from the ME. We have heard from his partner. We have also heard about the cell phone data that places our guy Tremaine right there. And let's go ahead and we'll get into this and get to our next portion. I got a call here. Wait a minute.
Courthouse and listen live to what's happening to begin the day today, Friday, of the Tremaine Jones trial.
Defense counsel, he's had it since yesterday. And we had the report of that transcript. We then put it in a Word document, the exact same transcript, so it doesn't have all the law enforcement data on it and things like that. I would like to give those to the jury so that they can read along. There is a jury instruction specifically on point to tell the jury how to use this transcript. We will not be moving it into evidence. It is not evidence, although I will ask that a copy get kept for the court for any appellate reasons. We will have the deputy hand them out to the jury, and as soon as that call is done, we will take them back from the jury. It is simply meant to be a demonstrative aid, and that's what Mr. Jones is requesting, a demonstrative aid for the jury so that they can both listen to and then also have the transcript so that they can follow along. But they obviously will be instructed by the jury or by the judge in that jury instruction that what they hear on the call is evidence, not necessarily what is in the transcript.
Exactly. All right, Mr. Jones, your position?
Yeah, Judge. So a few things. One, my first is I object to the transcript in and of itself. I worry that it'll distract the jury. They should just simply listen to the recording. However, I do recognize that providing a transcript to assist the jury is utilized at times. So that's my threshold objection. It doesn't sound like the state wants to admit the transcript as an exhibit. I understand it's got to be part of the court record. Obviously, I don't object to that if it's utilized. It doesn't sound like the state wants to enter it as an exhibit. That would have been a more strenuous objection. If that's not the case, then I will just leave it with what I've indicated so far. As far as the transcript itself that I've been provided, it mirrors the police report I've had. I also have the call. I've listened to the call. There's some words in here that are unintelligible that's noted in the transcript, but I don't have a dispute as to the veracity or the accuracy of the transcript as best as I can make it out, right? And so ultimately, I do want that instruction for the jury. I was trying to look it up when the state was
158.
Perfect. Then I will request that be read before the recording's played. I think that does help the jury. It also lets the jury know that why they're being handed the transcript. So that's where I'm at.
I think it is appropriate. It is permissible to allow for a transcript to be used. It will not be an exhibit. It does not itself become evidence. The jury instruction makes that clear. 158 recordings played to the jury. It reads, you are about to hear an audio recording. Recordings are proper evidence, and you may consider them just as any other evidence. Listen carefully. Some parts may be hard to understand. You will be provided a transcript to help you listen to the recording. If you notice any difference between what you heard on the recordings and what you read in the transcripts, you must rely on what you heard, not on what you read. So I will read that just before the recording is going to be played. Obviously, it'll be teed up with the foundational issues and things like that. And then we'll take it from there.
So then sorry, I thought you were done.
Nope, go ahead.
My only request is then when the deputy hands them up, the deputy can make sure he collects all of them. Just, we just want to make sure we don't lose track of them.
Absolutely, and they will be collected. They will be handed out by the deputy, not by Mr. Huebner, and the deputy will then collect all 14 of them. I've been provided with a copy now, so I have it, and we will then collect those back because they can't keep them and reference them and things like that. So we'll make sure of that.
Thank you.
All right. Anything else before we get started?
No, Judge.
Okay, great. We will bring the jury out then.
And with that, we are ready to go for the resumption of testimony as the state presents its case in the trial of Tremaine Jones, charged with 4 different felonies, including the most serious first-degree intentional homicide in the death of Milwaukee police.
Testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God or under the pain and penalty of perjury.
I do.
Please be seated. Please state your first, last name, spell both for record.
First name Troy, Troy. Last name Chadwick, Chadwick.
Thank you. Now, sir, I want to come back to you with State's Exhibits numbers 231 and 331. These are the reports that we were talking about yesterday. Is that correct?
Correct.
Okay. And just kind of to understand where we left off, we had already discussed the findings and your conclusions regarding the 2 .40 caliber firearms, each firing 2 cases.
Correct.
And we also discussed this AR-15 rifle and why it was an illegal weapon after being put together with various parts in Wisconsin.
Yes.
Okay. Now, I want to come back to State's Exhibit number 263. And when we are taking a look here at 263, which again remains and continues to be a safe weapon, regarding this particular weapon, did you test fire?
Yes, I did.
Was it a fully functioning firearm?
Yes, it is.
So it was capable of firing a bullet?
Yes.
Okay. Did you receive test-fired cartridges or test-fired casings as well as bullets that you were able to recover?
Did I receive them?
Did you recover them after you test-fired?
Yes, I test fired it.
Okay. Now, coming back just for one moment. I want to show you what has been marked as State's Exhibits, and this is going to be a long time here, so just bear with me here. State's Exhibits numbers 299, 301, 300, 272, 267, 265, 266, 276, 273, 269, 275, 271, 268, 274, 264, and 270. I would ask you to take a look at all of those for me and tell me if you recognize them.
Yes, I recognize these.
What are they?
These are 16 fired 223 or 5.56 caliber cartridge cases.
You just mentioned 223/5.56. Can you describe what that means?
5.56 by 45, also known as 5.56 millimeter NATO, is a specific caliber of a cartridge. It is technically a military designation for the 5.56 round. It is available on the civilian market as 5.56. 223 is the same exact caliber. It's the same exact round. It just has a civilian designation referred to as 223.
So those two calibers are the same?
Correct.
Okay. Now, you mentioned that there were 16 total 5.56 or 223 fired cartridges in this group that I just gave you.
Correct.
And if these were the fired 16 cartridge casings that were recovered from a backyard behind 2454 West Garfield, you don't necessarily know where they're recovered. You just know these are all 16 casings of the same caliber.
Correct.
Now, like we did with the other cartridge casings, I want to draw your attention, and using as an example State's Exhibit number 270, can we see that you in fact put markings on the casing itself to let us know that you were able to take a look and examine this particular case?
That is correct.
Did you do that for all of the cartridge casings?
Yes, I did.
Okay. Now, were you able to come to a conclusion as to whether or not those 16 fired 5.56/223 fired cartridge casings were all fired in the same firearm as each other?
Yes, I was.
What was your conclusion?
Based on my examination of the tool marks and the agreement of the individual characteristics, it's my opinion that all 16 of these fired cartridge cases were fired in one single firearm.
Now, I want to ask if you compared it to State's Exhibit number 263, this AR-15 short barrel rifle that you were asked to take a look at.
Yes, I did.
What was your conclusion?
So when comparing the fired evidence, all 16 of these individual items with the test fired cartridge cases that I personally recovered by firing that weapon, in my opinion, based on my examination, all 16 of these cartridge cases were fired in that firearm.
All 16 fired by this gun.
Correct.
Now, I would like to show you what has been marked as State's Exhibits numbers 282, 279, 280, and 281. I would ask you to take a look at those 4 exhibits and tell me if you recognize them.
Yes, I do.
What are they?
These are 4 more 223 or 5.56 caliber fired cartridge cases.
Okay. And if these particular cartridge casings were recovered kind of in a, I guess, front yard of 2480 on Garfield, or the intersection of 25th Street and Garfield, you don't know where they were recovered.
Correct.
You just know you took a look at these 4 additional casings.
Yes.
All right. And again, just using State's Exhibit number 282 as an example, can we see that again you marked it to make sure that we understand that you examined this particular cartridge casing to make any determinations?
Correct.
Now, regarding, did you do that for all 4 of those?
Yes.
Okay. Were you able to come to any conclusions as to whether or not State's Exhibits numbers 279 through 281 were all fired in the same firearm as each other?
Yes, I was.
And what was your conclusion?
Based on the examination of the tool marks and the agreement of individual characteristics, in my opinion, all 4 of these additional cartridge cases were also fired in a single firearm.
All fired in the same firearm?
Correct.
Did you make any conclusions as to whether or not these 4 cartridge casings recovered from the area of 25th and Garfield were fired by the same firearm that fired these 16 cartridge casings recovered from the backyard in the wooded area?
Yes, I was.
What was your conclusion?
When comparing all 4 of these additional cartridge cases with not only the group of 16, but also the test fires from the Palmetto rifle, in my opinion, all 20 total, including the 4, were fired in that specific firearm.
In this particular AR-15 short gun rifle,
Correct.
this firearm fired the 4 casings in one grouping and the 16 in the other.
Correct.
Now, I would like to show you, oh, let me get that back. I'm going to show you what has been marked as State's Exhibit number 319. I would ask you to take a look at this for me and tell me if you recognize it.
Yes, I do.
What is that?
This is crime lab item number 48 on this case, and it is a fired full metal jacket bullet.
Now, a couple things you said there. First of all, regarding the bullet, just so we understand, oftentimes the civilians refer to bullet as an ammunition, right?
Yes.
But a bullet has very specific kind of designation in terms of what you're referring to. What is the bullet? What is a bullet in this particular category?
I'm specifically referring to this as the projectile.
Okay, so this is the projectile. This is what goes down the barrel and is shot down at whatever you're shooting.
Correct.
Okay. Now, if State's Exhibit number 319 was recovered during the autopsy of Officer Kendall Corder, you don't necessarily know how that all plays out.
No.
You're just taking a look at what this is.
Correct.
Okay. Now, in terms of this particular bullet, were you able to come to any conclusions as to the caliber or the type of bullet that it is?
I cannot conclusively tell you what caliber it is, although I can say that it is a full metal jacket bullet and it has rifling with 6 lands and grooves.
Okay. And is that going to be important when we start looking at some of the other things we're about to talk about?
Yes.
Okay. Now, you mentioned 6 lands and grooves and rifles. What does that mean?
So earlier yesterday, when we were discussing the transfer of tool marks in a barrel, specifically when we were talking about the rifling and the helical pattern that is physically cut into a barrel that is rifling, there are various numbers or different ways that rifling can be done. And that was referred to by the lands and the grooves, which is the specific rifling, how many lands and grooves there are, and which way they twist. They can either twist left or right. Those are referred to as class characteristics, which are just general physical descriptions of a firearm or firearm characteristics.
Now, I want to draw your attention back to State's Exhibit number 263. Again, that AR-15 short barrel rifle. Its firearm barrel. What was its lands and grooves and what was its twist?
The rifling characteristics of that firearm specifically has 6 lands and grooves with a right hand twist.
Did you make any comparisons as to whether or not this exhibit, State's Exhibit number 319, recovered from the right shoulder of Officer Kendall Corder, was fired down this particular AR-15 short barrel rifle?
Yes.
What was your conclusion?
When comparing the rifling that I can observe on Court Exhibit 319 with the test-fired bullets that I recovered by firing that firearm specifically, I observed an agreement of individual characteristics, which means that in my opinion, based on my training and experience, this specific bullet was fired through the barrel of that firearm.
That gun fired that bullet?
Correct.
Okay. I now want to draw your attention to State's Exhibit number 233, a bullet recovered during the surgery of Officer Kendall Corder. Please take a look at that bullet.
I recognize this.
What is it?
This is an additional full metal jacket bullet, which is laboratory item number 30 submitted for examination on this case.
Now, were you able to come to any conclusions as to whether or not this particular bullet that we see here in State's Exhibit number 233 was fired down the same firearm barrel that fired 319?
Yes.
What was that?
Based on the agreement of individual characteristics, in my opinion, that bullet was also fired through the same barrel as that projectile, meaning they were also fired through the barrel of the specific firearm.
It was fired through that short barrel AR-15?
Correct.
Okay. Now, I want to draw your attention to another piece of evidence. State's Exhibit number 303, a Yes, bullet fragment that was recovered from Officer McCray during his surgery. You take a look at that and tell me if you recognize it.
Yes, I do.
What is this?
This is a fired bullet jacket fragment.
Can you explain what that means?
So when bullets are fired and they exit the muzzle of a firearm, they have to stop at some point, whether it hits something, somebody, or another object or the ground. It has to come to rest at some point. And that force will damage a bullet to a certain extent, even in the best of cases. And when that happens, depending on how the bullet was originally constructed, it may break apart. So this specifically is referring to the fact that this is not a full intact bullet. It is just a portion of the jacketing of a fired bullet.
When you're referring to the jacketing of a bullet, I'm just going to use State's Exhibit number 303 kind of as an example. We can kind of see in this bottom portion aspects of kind of both parts of the bullet. Is that fair?
Yes.
So when we're referring to the jacketing, is that kind of metal sheet that wraps around the kind of core of the bullet?
Correct.
What is that core of the bullet made?
Lead.
Okay, so when we're looking, for example, here at State's Exhibit number 319, we can see a fully jacketed bullet, but in the inside, kind of the back of it, we can see what appears to be kind of a grayer metal insert or something that is inside that container. Is that fair?
Yes.
So that would be the lead core with the jacketing around.
Yes.
All right. And if we're looking here at State's Exhibit number 303, you can see what appears to be a fragment of the core as well as a fragment of that jacket.
Yes.
Now, on the core, is there any ever tool marks that you can use to kind of look at a core to figure out if it was fired by a firearm barrel?
No.
Because that's what the jacket.
Correct. The tool mark transfer happens from the rifling in the barrel to the jacket. The core is the inside of the jacket, so it does not receive any transfer of tool marks.
The jacketing position is to get gripped and then spun to give us that distance and that accuracy.
Yes.
Now, in this particular case, we have what appears to be a fragment. Are you still able to conduct an analysis to determine what type of barrel fired that jacketing?
Yes.
And did you do so in this case?
Yes, I did.
What did you determine?
So there are observable tool marks present, even though this is just a portion of the jacketing. I was able to observe that there are conventional rifling impressions, which can be observed and measured and used for comparison.
How many lanes and grooves and what twist was there on this particular one?
There's not enough to conclusively say how many there were on the original bullet, but there were observable land and groove impressions on this fragment.
Now, in terms of those observable lands and grooves impressions, even though you don't have the full everything we've talked about, can you still use that to try to make an identification?
Yes.
Did you do so in this case?
I did.
Explain what your conclusion was.
So based on the comparison of the observed rifling impressions on Court Exhibit 303, the fired jacket fragment, I compared that with the test fired bullets from the AR-15 rifle we are discussing. And based on the agreement of the tool marks and the individual rifling impressions, in my opinion, this fragment was part of a bullet that was fired through the barrel of the AR-15.
So this fragment was fired on the same short barrel rifle. I'm sorry, this 303 was fired on the same short barrel rifle that fired the two bullets that were recovered from Officer Corder's body, both during surgery and during the autopsy.
Correct.
Now, last piece of evidence that I would like to discuss with you. I'm going to show you what has been marked as State Exhibit number 236. A metal jacket fragment recovered from Officer McCray's vest. Can you please describe what we're looking at here?
This is also a portion of a bullet that I will refer to as a fired bullet jacket fragment.
Again, is that part of that kind of like jacketing that goes around the floor?
Exactly.
All right. And this appears to be even smaller than the last part.
Yes.
Were you able to see any tool mark impressions on?
Yes.
Can you describe what you saw and what conclusions you made?
So there are observable rifling impressions on this fragment Court Exhibit 236, which are consistent with class characteristics of not only the three previously discussed fire projectiles, but also the rifle. So when I compare the observed tool marks present on this specific jacket fragment with the test fired bullets I recovered from the rifle, there is an agreement of individual characteristics, meaning that this fragment was part of a bullet fired through the barrel of the AR-15.
So that short-barreled rifle fired the fragment recovered from Officer Corder's from his vest. The fragment recovered from Officer Corder or Officer let me start again. 236. He fired the fragment recovered from Officer McCrae's vest. He covered the fragment recovered from Officer McCrae's foot, and he fired the two bullets recovered from Officer Kendall Corder's body.
Correct.
Is all of those conclusions that you just discussed relating to all this firearm evidence in your reports, states exhibits numbers 231 and 331?
Correct.
And the state would move 231 and 331 in if I'm not already noticed.
I don't object.
Received without objection.
I have no further questions.
Thank you. Cross?
Sure, I'll just wait till the state sits. All right, so I just want to work backwards. Your conclusions are essentially as follows. You have a 40 caliber casing that ties out to the Glock, correct? Two of those.
Correct.
Two 40 caliber casings that tie out to the Smith & Wesson, true?
Correct.
Then you have, and that's the end of the analysis for those two firearms and those casings, fair?
Yes.
You didn't have any fragments or anything that you believe came from the 40 calibers.
Originally, when we first conduct our analysis, all of the projectiles would be open for comparison to all of the firearms, but based on the class characteristic differences of all three, they were primarily compared against the rifle and not the two pistols.
Right. When you say class characteristics, those are the larger characteristics that you're going to see the rifling that's essentially set by the manufacturer, fair?
Yes.
Meaning every Glock might have 7 lands and grooves or 6 lands and grooves, right?
Correct.
So if every Glock in this hypothetical has 7 lands and grooves, you have a fragment or a projectile with 5 lands and grooves, you know it didn't come from a Glock.
Exactly.
Okay. But then you also look not only at the class characteristics, sort of the bigger things, you also look at the microscopic or individualized characteristics as well.
Yes.
Okay. And you basically are looking at all of these, both the casings and the fragments underneath a microscope and comparing basically the scratches or the markings that are made when the bullet either goes down the barrel or the casing's ejected from the firearm. True?
Yes.
And the theory is in tool comparison is that every time a tool makes a mark on something, it's sort of creating a unique signature on how it's extracting a cartridge or how a projectile goes down the barrel of a gun. True?
Yes.
And those would change over time, but slowly over time. Fair?
They can change over time, but those changes are very minor.
Right. Meaning if I buy a gun today, fire off 5 rounds and you compare them, right? They're going to look very similar at the microscopic level. True?
Yes.
If I then use that gun every single day for 20 years and then fire a bullet 20 years from now, compare it to the day I bought it, there's going to be some microscopic changes. Fair?
Yes, I would expect to see minor differences.
Because of wear and tear on the actual metal against metal, basically.
Yes.
Okay. In this case, though, after you had considered the 40 caliber casings, you then turned your attention to the rifle casings.
Yes.
The rifle casings, there's 20 of them in this case. True?
Yes.
16 in one group, 4 in the other.
Yes.
It's your opinion that all 20 came from the same firearm, specifically the firearm here today, right? The Palmetto.
That's correct.
That again is based upon the microscopic markings of what's on the left on the casings. True?
Yes.
Okay. Now, fair to say that there isn't a standardized number of markings or similarities of markings that every firearms and tool examiner would use, right?
Correct.
Okay. In other words, you just believe, in your opinion, based on your training experience and looking through the microscope, when you're comparing them, that there are sufficient enough markings for you to render an opinion that they match. Fair?
Yes,
I assume then also your work is peer reviewed, true?
it is. Yes.
What that means is that someone from your lab internally also looks at your work and sees if they come to the same conclusion.
Correct.
But you don't, your lab does not send out your findings to another lab to independently verify, do you?
No.
Just internally you do a peer review.
Correct.
On the fragments, you get less data generally or less information, at least in this case, than you would off of a casing. Is that fair?
I wouldn't say it's more or less, but because of the nature of the fragment, it's incomplete.
That's a better way of putting it. So you have less pieces to the puzzle, but you believe in this case you had enough pieces to that puzzle to make a comparison on the fragments.
Yes.
I have nothing else. Thank you.
Thank you. Redirect?
And based on all of that, you were able to determine that all 20 rifle rounds were fired by that AR-15 short barrel rifle.
Correct.
You're able to determine that all 4 bullet projectiles or fragments that were recovered from both officers were fired by that same AR-15 short barrel rifle.
Correct.
No follow-up, Judge.
Thank you. Thank you. You may step down.
Thank you.
All right, Mr. Hubner, you may call your next witness.
Your Honor, the state calls Detective Driscoll.
You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God or under the pain and penalty of perjury?
Yes, I do.
Please be seated. Please state your first and last name and spell them both for the record.
My name is Michael Driscoll, Michael Driscoll.
How are you employed?
I'm a detective for the City of Milwaukee Police Department. I'm assigned to the Homicide Division early shift.
How long have you been with the Milwaukee Police Department?
I'm in my 20th year with the police department. I'm in my 6th year as a detective,
And how long have you been with homicide?
5 of the 6 years.
Now, Detective, I want to draw your attention specifically to the homicide investigation into the death of Officer Kendall Corder that occurred on June 26th, 2025. Specifically regarding that, were you involved in aspects of that investigation?
I was involved, yes.
For example, who's your partner?
Justin Sokolowski,
Were you with him when he went to Freighter to get those 2 bullets?
that's correct.
Now, I want to draw your aspect or your attention to another aspect of this investigation. Are you familiar with what's referred to as a jail call?
I am very familiar with it, yes.
Okay. Is there a system that monitors or records these calls?
Yes, it's a web-based recording system. It's called IC Solutions. We get access through it through the Milwaukee County Sheriff's Department. It's a fairly easy database. We have our own logins where we log into this computer system, and every single call or even attempted call by someone who is incarcerated, specifically in this case at the county jail, they are recorded and subject to monitoring by us.
Now, I want to just kind of talk a little bit about your familiarity with the system. Do you have access to this system?
I do have access, correct?
Do you use this system in order to monitor individuals that are at our county jail, to monitor their jail calls?
I use it frequently, yes.
Do you use it kind of throughout your job as a homicide detective?
Yes, very much.
Is this something that is often done in your duties?
Yes, almost every day.
Now, your training experience in how to use the system and how the system is set up and all of that, is that fair?
That is correct. I was trained in it when I became a detective. And to be honest with you, it's not super difficult.
Now, let's just talk about how the system works in kind of identifying or tracking a particular call to a particular person in the jail. How does that work?
Okay, so when someone is booked in at the sheriff's department, they're given a specific inmate ID. They call it an inmate ID. It's kind of what we refer to in the Milwaukee Police Department as like their booking number. So everyone has a specific inmate ID. So to access the jail calls, they're then further given a PIN number, kind of like your PIN number for your bank account. Everyone gets their own specific PIN number. So for someone to make a jail call out of the jail, they have to go through a series of prompts that are recorded that on my end I can hear. So they pick up the phone and they hit the voice prompts if they want it in English or Spanish. Then from there, they have to enter their unique inmate ID and their unique PIN number. From there, they have to voice recognize, the system voice recognizes, they have to say United States of America for the system to continue on. From there, they dial in the number they want to dial. So the person they want to call, they put that number in. And then the system connects to the person and asks them to hit 1 or 2 if they want to accept or reject a call from an inmate who is incarcerated at the Milwaukee Criminal Justice Facility. And then it says in the person who's dialing out's name. So for instance, if it was me, it would say, will you accept the call from Michael Driscoll, who's incarcerated at the Milwaukee County Justice Facility? Do you accept or decline? So if they accept, there's an automated recording that says that the calls are recorded, all calls are recorded, and they are subject to monitoring at any time. And this gives the warning that it is a recorded call and it can and will be listened to, so that both parties, the person dialed and the person calling, both know that they're on a recorded line. And after that warning is when they're able to have a back and forth regular telephone conversation.
Okay. Now, exactly, to be fair, people can kind of hit that one right away once the call comes in.
Correct. If you get a lot of calls from the jail, you know this preamble. So as soon as you hear it, boop, you can hit 1 and you can kind of jump to the conversation.
Now, I want to draw your attention to listening to a series of phone calls or kind of monitoring an inmate number 2025011410. Who was the individual that was associated with that inmate number?
That's the inmate ID for Tremaine Jones.
Do you see that individual in the courtroom today?
I do. He's at the table to the right, wearing the white collared shirts.
Does he have time?
He does not have a tan.
Your Honor, may the record reflect the fact that it's looked at, described, and identified in the past.
It's accurate.
All right, the record will so reflect.
And during these calls, are they associated with the inmate number of the defendant?
They are all, yes, under his inmate ID for him.
And that would mean requiring to use the defendant's PIN then in order to make these calls.
That's correct.
Now, this system, in terms of making these phone calls, bills out like per minute, is that fair?
It does. They are allotted some free calls at times. I don't know the procedure, but a lot of times it is billed. They have to have like money on their books to make calls.
Even those free calls, there's a limit on them. So this system is designed to keep track of exactly how many calls each particular inmate is using.
That's true. Correct.
Now, when you listened to the calls being made by the inmate number and PIN number associated with the defendant, in preparation for listening to that, did you kind of view any interaction with MPD, Milwaukee Police Department, to kind of understand what his voice sounded like?
I did.
What was that?
I reviewed when Detective Breitenhart and Detective Flores, some of my coworkers, obtained Buckle Squad, the DNA, their interaction with him and the conversations they had with the defendant, Mr. Jones. He spoke with them, and I reviewed that recording of him.
Additionally, these calls, and we're only going to play one, but in regards to the calls that are being made by this PIN number and this ID number of the defendant, are they to his family members?
They are, yes.
Is he referred to as Tremaine in these calls?
He is, by his mother, yes.
Now, in fairness, inmates do have the ability to lend out their PIN, is that fair?
They do.
And when you're monitoring, do you ever, can you sometimes run across this when you're monitoring certain individuals' PINs?
I do. It does happen. And so most people who are making calls call about maybe a handful of people, mom, families, a couple family members. If I'm monitoring someone's jail calls, you kind of, you get into their conversations and their flows, and you know kind of who they're talking to. And then all of a sudden, a new number pops up, and you're wondering, oh, he's calling somebody new. But then when you monitor it, it's a whole new voice, and it's a whole new conversation, and it's not related to anything you've already monitored. So this is an instance where one person let another inmate use his PIN, and it's usually just like a one-off.
Did you ever encounter anything like that in listening or monitoring the defendant's calls?
No, they were all him.
Now, I want to draw your attention specifically to a phone call that occurred on July 2nd of 2025 at 16:39. Are you familiar with that call?
I am familiar with that call, yes.
Did you monitor that call?
I did monitor that call, yes.
Did you download that call from IC Solutions?
I did.
Have you listened to it in preparation for today's trial?
I have.
Is this what we have, which is, Your Honor, the folder and the audio file on State's Exhibit number 329? That exhibit has already been moved into evidence. I'm moving in another audio file from that CD. That is a jail call, or a call on there that is labeled inmate 2025011-410, comma, Tremaine D, ending in 3040. I'll be moving in and playing the portions of that call from 14 minutes and 48 seconds to the end of that call.
Any objection?
No.
Received without objection.
Now, detective, in this call, just so we understand, the defendant's voice, is it a little low?
It is, yes.
And who's he speaking to?
His mother, Valencia Eaton.
And her voice is a little high.
Correct.
Your Honor, before we proceed on to the jury instruction and to this, I would like to make the record, just so we have this, so the jury understands, based on the best audio equipment that the county can buy, we have that audio equipment currently set up to the highest level. That will allow us to hear the defendant's voice, but the other voice, the female voice, will be a little loud and distorted because hers is very loud. As a result of that, we have created a transcript so I would ask the court now to read the jury instruction, and then once you're done, the deputy to hand those out.
All right. You are about to hear an audio recording. Recordings are proper evidence, and you may consider them just as any other evidence. Listen carefully. Some parts may be hard to understand. You will be provided with a transcript to help you listen to the recording. If you notice any difference between what you heard on the recording and what you read in the transcript, You must rely on what you heard, not on what you read. So you're going to have them to listen while we play it, and then they'll be collected back from you. So you won't be keeping the transcripts, okay? All right, you may pass those out, Deputy. I've made our system as loud as possible. Warning, it's going to be loud for half of it.
And I am going to crank our system as well. All right, at this point, I will be playing at 14 minutes and 48 seconds into the recording. Essentially. Oh. One moment, Judge. Had it working just a second ago.
Ladies and gentlemen, you shouldn't be reading the transcript while we're waiting. I know that it's tempting to do so. It should just be to assist you as you're listening.
Waiting for the CD to catch up.
For that.
Yep.
I'm not. We're not focused on that right now. I'm not focused on that right now. What this one is okay when bro came out, did what he did towards me. I didn't instantly react. I might have let off in the air beforehand, whatever the case might be, but I didn't instantly react to that. So I followed my instinct and I got up out of there. That's what I did, man. And I went to literally get myself together. Get all my stuff together, put in my bag, I'm getting ready to leave. As the post, this thing, if the police are responding to me, you don't be expecting them to be in that car, see flashing lights, or hear sirens or something. You know what I'm saying? And this is the fact of the matter. Regardless of what anyone said or nobody right here, the police coming up. No, I was not aware of any of that. I would have never sat in one place. When that stuff happens, you bump heads, did I sit there at your house? No. I moved away for a minute. I did what I had to do. So, I still let them come and detain me though. I didn't want to. I'm not stupid, man. I'm not stupid. I just want y'all to know, no, the boy didn't crash out. No. I was so fucking scared, man. I'm not telling you, that shit get me so emotional because it was like, bro, I'm so fucking scared. Both of these people who I ain't know who was what were walking closely as fuck together like they just two random people from the hood or something. Like, what the fuck if y'all was, wait, bro, like that shit threw me off. That shit threw me off, I'm not gonna lie. Nobody flashed no flashlight at me. Nobody said, hey, Milwaukee Police Department, freeze, if you can see me, you can. None of that. And I sat there So to get up and move, then that's when I looked up. Seen them walking closely as fuck together. And they stopped point blank in the alley. Stopped. A cool 10 seconds and I went, mama. And one of them, I seen him holding something like pointed towards, and it wasn't a flashlight, Mom. I promise you, I ain't telling you no lies. It wasn't a flashlight. And I'm sure the body cam can prove that as well. It wasn't a flashlight. That's what my reaction was. My reaction out of fear. Out of fear, not even knowing. Like, okay, if people are already seeing y'all blocks away, that was them. I wasn't over there for that month. I was already gone. I was literally gathering my stuff in my spot and ready to move from that spot and go back home. I promise you, Mom. That shit eat me up. That shit eat me up. I ain't gonna lie to you.
I know it is, man. I told you I'm gonna try my best.
For me, I ain't even praying for my freedom for real. I've been praying for him, Mom.
I know.
Man, family, Mom, for real.
I mean, as long as you know, son, like, baby, and there's a law that's out here that, I mean, they can hit you with some charges because they're cops.
I know.
No, for sure, you know, and from that evidence that they have, it's piled up against you. That body cam, yes. I mean, that may prove that it wasn't intentional.
It wasn't, Mom.
You know, so that's a good thing. If we can get access to that, that's a good thing. Like I said, it'll bring some of them charges down that they're trying to hit you with.
Oh, Mom.
I don't know how long you have to come up with an attorney.
Well, what's today, Tuesday?
Wednesday.
It's Wednesday.
1 minute remaining.
Yeah.
Oh, man.
Hello?
Yeah, I can call
Hello?
you back. I can hear you, Mom. I just got.
Hey.
Yeah, can you hear me?
Yeah, I can hear you now.
I said I could call right back right quick just to.
Okay.
Let me call right back before it just hang up.
All right.
We'll gather up the transcripts from you folks. We need all of them.
Is that the recording you listened to made by the defendant to his mother on July 2nd
That is the recording, yes.
of last year?
Correct.
Nothing else, thank you.
Thank you. Cross?
Thank you. Let's just back up a bit. So you're saying in this case, there wasn't anybody using someone else's PIN number that you at least discovered, fair?
Correct.
So you were able to figure out all the calls that Tremaine Jones had made while in jail, true?
No, I listened to 22 of them from June 30th to July 5th. That's the only calls I listened to.
Right. What I'm saying though is that as far as you know, those are the calls that he made, meaning you don't have any suspicion he made calls on some other PIN, backdooring or anything like that, is what I'm saying.
Correct.
Okay. So out of these, you listen to those 22 calls, right? In the context of those calls, this is just what we heard is about 5-minute segment of one of those calls, true?
Yes.
Okay. Are you also aware that Mr. Tremaine Jones was arrested on June 27th?
Correct.
Okay. And this phone call was on July 2nd that we just listened to.
Right. I don't know when he got shipped from MPD, which does not have jail calls, to the sheriff's department where he was able to start getting his jail calls.
Right. Do you remember the first date of the first jail call you listened to? If it was earlier than July 2nd?
I believe it was, I believe the one we just listened to was the 8th call I listened to. So I believe it was a day or two previous.
Okay. So the point is he gets arrested on the 27th. It takes a day or so. I'm not holding you to it specifically, but this is just generally the way it happens for then people to get processed and then moved to the county jail. That's generally the process. Fair?
Correct.
So it's reasonable to assume he would be at the jail by maybe June 29th or so, June 30th, somewhere in that range?
Yes.
Okay. My point is, though, this phone call is 5 days after his arrest. That's true.
Yes.
Okay. He also made multiple calls prior to this call we listened to. True?
I
Said this about his
believe-
8th.
I think he made 2 or 3 prior to me listening.
Okay. So you said this is about the 8th one you listened to, and he had 2 or 3 prior, so maybe a dozen calls before this one? Is that what you're saying?
Yes.
I'm not holding you to the exact number, but, and then are you also aware that he was charged with this crime on July 1st?
Yes.
Okay. So this call was made 5 days after his arrest, yes?
Yes.
And 1 day after he was formally charged, correct?
Yes.
Thank you. I have nothing else.
Thank you. Any redirect?
1 day after he's formally charged with the death of Officer Corder, he makes his call.
Correct.
He's describing what he's seeing at that alley from those bushes.
Objection calls for his opinion. The recording speaks for itself, Judge.
Sustained.
Does the defendant ever say he didn't do it?
No.
Does he ever say there's anyone else there?
No.
He just says it wasn't intentional.
Correct.
Okay.
No follow-up to that, Judge. Thanks.
All right. Thank you. You may step down. And call your next witness.
One moment, Your Honor. Your Honor, state rest subject to rebuttal.
All right. Okay, ladies and gentlemen, the state is rested. That means we have to do some work outside your presence. So I'm going to send you back to the jury room. And you all know what I'm reaching for. Do not research any information that you personally think might be helpful to you in understanding the issues presented or investigate this case on your own. Do not read any newspaper reports or listen to any news reports on radio, television, or any other electronic application about this trial. Do not seek information regarding the public records of any party or witness in this case. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use any electronic device to share any information about this case. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. We'll get you back. It won't be a real quick one, so it may be about half an hour or so, but we'll get you back as soon as we can, and we'll continue on, okay? Thank you so much. Enjoy your break.
So as they're following now, guys, I put in what he is currently being charged with. I guess my question
And with that, we have
what do you guys think?
reached a check mark, so to speak, a mile marker.
The state
Officer
has
Kendall
rested their
things go
case.
for 5.
I don't
So
want
just
to
a
talk
few,
to him.
like, not to moment.
Hey,
just before
hey, my guy, calm it down.
their
Okay,
fault
let me see.
call Bryce, someone else fired those shots. But we just now the Grant Hebner situation where you actually see losing his life of their own aid from arguments after it means
Mr. Jones, Ms.
Thank
Rattach,
goodness
was
for
it
this TiVo time. So before we go back into court, guys, I do have a question. So when we're looking at his charges, first degree intentional homicide, do y'all think this was intentional? Put a 1 in the chat if you think that this was intentional. Okay, I'm seeing some ones come in the chat. Okay. I don't know, because kind of part of me don't feel like it's intentional. I do feel like it's reckless. The first degree reckless endangering. I just don't, I don't know if I really think that he was trying to pew a cop. I guess that would be my thing. Like, I don't know if he was really trying to pew a cop, but he was definitely reckless with it. Definitely reckless with the weapon. So I'm thinking that maybe one of the depending how the jury looks at it and what they do at the charge conference, I don't know if the first degree intentional homicide, because that seemed like, I mean, the ambush stuff, y'all, that's just because somebody said he was in the bushes. You know, our guy that was following him around said he was in the bushes. So that's probably where the ambush came from, because he was lying in wait, I guess. But I just really don't. Yeah, I definitely think it was reckless. I don't think that I don't know if they announced that they were cops coming down there. I think that the young man, I don't think he knew it was cops. Because even after he spoke to the young man, I think he thought it was the other guy that was pewing out the window. Because when he spoke with our homie that was, you know, the young man, little homie that was following him around doing the video recording so he can do it for the gram. You know, we doing it for the gram. So he can put it on the gram. He said that when he, you know, seen him after the pewing, Tremaine asked him like, I thought it was that other guy. And the young boy was like, well, nah, it was the cop. So yeah. But let's see how they do in this charge conference in regards to everything. Let me pull it back just a little bit for us. And let's see. I don't know. Is he gonna testify? The state has rested. We thought we was gonna get 150 witnesses, but we didn't get 150 witnesses. Thank goodness. I think we understand the story. So I'm cool with that. And let's see what we have here. Is he gonna testify? I think not. He can't testify.
Motion simultaneously, or do you want to do motion? Well, okay. At this point, Judge, I'll move to dismiss without argument.
Dismiss all of it.
At this point,
Denied.
take the evidence in the light most favorable to the state. I do believe that there is evidence in this record that a reasonable jury could use to convict Mr. Jones on each of these charges. So I am going to leave it to the jury to render their decision. So I'm going to deny your motion. You wish to do the colloquy now?
Yes, Judge.
All right, Mr. Jones, I'm going to start with your lawyer. Then I'm going to ask you a bunch of questions. Then I'm going to go back to your lawyer, okay? I'm not trying to change your mind or anything on anything. I'm simply wanting to make sure that we are getting a full and complete record to make sure that you are making a knowing decision, okay? I'm sorry, I assumed Mr. Jones, Ms. Ruckdaschel, is it you? It's Mr. Jones. All right. Mr. Jones, have you discussed with your client his constitutional right to testify as well as his right not to testify?
Yes.
And has your client made a decision in that regard?
Yes.
And what is that decision?
My understanding, he will elect not to testify.
All right. Mr. Jones, sorry, I'm just using Mr. Jones all over, Mr. Tremaine Jones. Do you understand you have both a constitutional right to testify as well as the right not to testify?
Yes.
Do you understand that you do not have to prove your innocence, but that the state must prove your guilt beyond a reasonable doubt?
Yes.
Do you understand that if you would choose to testify, you would be subject to cross-examination by the prosecutor, meaning you not only answer your lawyer's questions, but you'd have to answer all of his questions unless I told you you didn't have to?
Yes.
And do you understand if you choose not to testify, the state cannot refer to that fact?
Yes.
Do you understand that your silence cannot be used against you?
Yes.
Have you had the opportunity to discuss your decision to testify or not testify with your lawyer?
Yes.
Or lawyers, I should say. Have you had enough time to discuss your decisions with your lawyers?
Yes.
And have you made a decision as to whether you will or will not testify?
Yes.
And what is that decision?
I will not testify.
All right. Has anyone, including your lawyers, made any promises to you or offered you anything to arrive at your decision?
No.
Has anyone, including your lawyers, made any threats, pressured you, used any force, or in any way coerced you into making your decision?
No.
Have you used any drugs or alcohol within the last 24 hours?
No.
Are you under the influence of any drugs or alcohol?
No.
Are you currently using any prescription medication for any mental condition?
No.
Are you currently suffering from any mental condition which is affecting your ability to think and to make decisions?
No.
Have you made your decision freely, voluntarily, knowingly, and understandingly after having thought about your decision and after having fully discussed it with your lawyer?
Yes.
Having thought about everything we've discussed, is it in fact your decision to not testify?
Yes, it is.
All right. Back to you, Mr. Jones, Russell Jones. You said you had fully discussed with your client his constitutional right to testify as well as his right not to testify. Are you satisfied that he understands what those rights entail?
Yes,
Have you advised him of your professional opinion in that regard?
I have.
Has anyone made any threats, promises, used any force or coercion toward your client with respect to his decision?
Not that I'm aware of.
Are you satisfied that he has made his decision freely, voluntarily, knowingly, and understandingly?
I am.
All right. Based on those colloquies, the court finds the defendant is waiving his right to testify freely, voluntarily, knowingly, and understandingly. All right. The state has rested. Does the defense anticipate calling other witnesses?
No, Judge, I anticipate resting in front of the jury. So at this time, I would ask the court for a directed verdict of not guilty on all counts without further argument.
All right. Mr. Huebner, do you wish to be heard?
The line is favorable to the state. You have enough to go forward.
All right. I agree. There is evidence in this case that a reasonable jury, I don't have any idea what they will do, but there is evidence in this case that would support a verdict in favor of the state, and therefore I am going to deny your request for a directed verdict. I'm going to go over now. I've talked with the parties about the instructions that we have discussed. Given that, I'm going to just go over them. Everybody has agreed in the back. I will start with 100, the opening instructions. 115, one defendant, 4 counts. Then I go into the language from the information as to count 1, and 1018, first degree intentional homicide, first degree reckless homicide. Mr. Jones, do you wish to make a record as to why these lesser included or have been included in the jury instructions?
Yes, Your Honor. So we are specifically requesting on counts 1, 2, and 3 for lesser includeds to be considered by the jury, respectively, on count 1 for first degree reckless homicide to be considered. With respect to count 2, given that it's an attempt, it would be a first degree recklessly endangering safety. And on count 3, it would be second degree recklessly endangering safety. We're making that request after discussions with my client. My client understands the nature of the request, why we're making that request, and we're asking the court to do so.
All right. State's position?
Well, and sorry, and obviously I'm asking because I think the evidence could support them.
Understood.
Your Honor, as the court knows under the law, if the court determines that the evidence could support a lesser included. No, I'm not going to go that. Then I would say that, as the court knows, in regards to the lesser included, if the evidence could support a finding of guilty as to the lesser included offense, and one of the parties asked for it, the court has to give it. I think based on the evidence, while I don't think the jury should, they could, and therefore I have no position.
All right. I agree. That is the state of the law. I think there is, as I said, I don't know what the jury is going to do. I believe these lesser includeds are supported by the evidence. So I'm not certain, like I said, that it will be up to the jury to make that final determination. But as they are requested, I will give each of those. And in that vein, obviously I knew that because we talked about it in chambers. I'll give 1018, first degree intentional homicide with first degree reckless homicide as a lesser included. Count 2, I do talk about, take the language from the information and include that. Then 1070, attempted first degree intentional homicide. There's discussion of that. That is not a pattern instruction with the lesser included. So I include 1345, first degree recklessly endangering safety. And then we get to count 3. I include the language from the information and again give 1345. I'm going to read it twice. I think that is the best practice here because in count 2, it's a lesser included. In count 3, it's the charged offense. And then I do go into 1347, the second degree recklessly endangering safety as that lesser included. 990, using or possessing a dangerous weapon. Each of the first 3 counts are charged as while armed. So the jury will have to answer special questions about that. So I explain that in that instruction. On count 4, I include the language from the information. Then 1342, possession of a short-barreled rifle. Then getting back into kind of the general instructions. 103, evidence defined. 140, burden of proof and presumption of evidence. 145, information not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 155, exhibits. 157, remarks of counsel. 160, closing arguments of counsel. 170, circumstantial evidence. There is a paragraph embedded in 170 that encompasses evidence of conduct after the alleged crime was committed. It is not separated out into 172, which is entitled flight concealment. It's just embedded in 170 under circumstantial. 190, weight of evidence. 195, jurors' knowledge. 200, this is in the jury instructions, says expert opinion testimony. I have taken out the word expert. The people who testified, their credentials were put on the record, but they were never identified as experts. I think that is the most appropriate way to do that. So that opinion evidence, or 200 opinion testimony, is the way that is designated. 300, credibility of witnesses. Are you asking for 315?
I am, Judge. Thank you.
All right, so I will put that in. Defendant elects not to testify. 325, impeachment of a witness by a prior conviction or juvenile adjudication. We did have a couple witnesses that did have prior convictions that were mentioned, so that is appropriate to include. There's just a little paragraph about who's going first in closing arguments. Then after, we will then pause. After that, we'll go into 460, the closing instruction. 480, verdict submitted for one defendant, 4 counts. There are 11 different verdict forms that will be submitted to the jury, including to encompass all the lesser includeds and each of the charges. Those are in the front pocket of the binder. So I go through all of the questions that are contained on those. Then we will select the alternate juror, and 515, unanimous verdict and selection of presiding juror. Is the state okay with those jury instructions that will be presented to the jurors?
Yes.
And the defense?
Yes, Your Honor.
All right. Just for people who are watching, this is what we're going to do. When the jury comes out, we've already collected their notebooks. I will ask Mr. Jones if he has any witnesses. You will rest. The state obviously will not be putting on any rebuttal witnesses. I will tell them that is why we have gathered their notebooks, and I will go into the jury instructions. I'm going to tell them what our plan is. It is 10:44. I'm going to read the instructions. After the instructions, we need to switch out our court reporter. Our plan is, and this is what everybody has requested, I'll give them a little comfort break. I'm going to tell them that we're planning to work through lunch. My staff has agreed to that graciously. So we will plan on that. I will tell them that we will order lunch for them and they will get it when they go back to do their deliberations. But we will work through. As soon as I'm done, we'll take that short comfort break just for everybody to switch out the court reporters and do whatever. If anybody needs to use the restroom in the back, and let anybody know that they're not coming out to lunch today if that was someone's plan, because I told them on the first day the only reason that they would not be free at lunchtime would be if they were in active deliberations. We'll work through, we'll do the closings, get the alternates selected, and then send them back for their deliberations, working through the lunch hour. Is that acceptable to the state?
Yes.
The defense?
Yes, Your Honor.
Okay, great. Do we need a quick break now, or are we ready for them?
Right. After you read, you get one, right? Yes.
Yes, okay.
Thank you.
Talking about getting it done before.
So
Easter.
we are hearing things are moving quickly now as
Good grief.
part of his defense team
of law, which we're going
She said, "No, we about to work
Should
through
have
this lunch, baby.
all right, everyone.
Y'all can deliberate and eat." She not playing. They about to go into closing arguments. We about to get this done. Welcome to the Sweet Pea Gang, Trisha. Welcome, welcome, welcome. Oh, it's on your. It's a quick trial, actually. I put a little thing together for us on the page, so it's a playlist. So if anybody missed it, it was only a 4-day trial. You can see right now we are into we about to go into closing arguments. We'll have a verdict today. We'll probably have a verdict today. Wow, this judge said, "Shit, we working through lunch. They gonna take a comfort break and we getting this done." All right, let's go in here. This is my type of trial, baby. In and out. We've been doing 3 weeks in Hawaii. I'm so over that one. I like trials like this. Let's get in, out, and let's move on.
Openings, closings, or the instructions. I'm about to get into the instructions. I'm just going to give you a heads up on how we're going to proceed. We're at a weird time. It is 11:15. We've always taken our lunch break at about noon, right? I told you the only time we would work through lunch would be if you were going to be in your deliberations. What we're going to do is I'm going to read to you the instructions, which are lengthy. They have been printed out and they are in a binder for you. So I will read those to you. I will give you a short comfort break so we don't have a long running time where you're just sitting in the box and listening. I'll give you a short comfort break. We need to switch out our court reporters. And as soon as we're ready to go, then we will get into the state will do their closing. The defense will do their closing, and then the state will have an opportunity for rebuttal. Your lunch will be waiting for you when you go back to do your deliberations. Those of you that are selected as alternates, I will talk with you privately, okay? But you'll get your belongings and whatever. So at this point, we're ready to get into the instructions. So members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial, and the law is given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Count 1 of the information reads as follows. The above-named defendant, on or about Thursday, June 26, 2025, at or near 2454 West Garfield Avenue in the alley in the city of Milwaukee, Milwaukee County, Wisconsin, did cause the death of Officer Kendall Corder, another human being, with intent to kill that person, contrary to section 940.01 sub 1 sub A Wisconsin statutes. The defendant has entered a plea of not guilty to this charge, which means the state must prove every element of each count charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of first-degree reckless homicide, which is a less serious degree of criminal homicide. The crimes referred to as first-degree intentional and first-degree reckless homicide are different types of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. Both intentional and reckless homicide require that the defendant cause the death of the victim. First-degree intentional homicide requires the state to prove that the defendant acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly under circumstances which show utter disregard for human life. It is for you to decide what type of homicide the defendant is guilty, if guilty at all, according to the instructions which define the two offenses. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant caused the death of Officer Kendall Corder. Cause means the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with intent to kill Officer Kendall Corder or another human being. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill must be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Officer Kendall Corder with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty of first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of Section 940.02 sub 1 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02 sub 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Number one, the defendant caused the death of Officer Kendall Corder. Cause means the defendant's act was a substantial factor in producing the death. Number two, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Number three, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all the other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Officer Kendall Corder by criminally reckless conduct and that the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you are not so satisfied, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one offense with regard to count one. Count two of the information reads as follows. The above named defendant, on or about Thursday, June 26, 2025, at or near 2454 West Garfield Avenue in the alley in the city of Milwaukee, Milwaukee County, Wisconsin, attempted to cause the death of Officer Christopher McRae, another human being, with intent to kill that person, contrary to section 940.01, sub 1 sub A, 939.32 Wisconsin statutes. The defendant has entered a plea of not guilty to this charge, which means the state must prove every element of each count charged beyond a reasonable doubt. The defendant is charged with attempted first-degree intentional homicide. The crime of attempted first-degree intentional homicide, as defined in section 939.32 and section 940.01 of the Criminal Code of Wisconsin, is committed by one who, with the intent to commit first-degree intentional homicide, does acts toward the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he or she had formed the intent and would commit the crime except for the intervention of another person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant intended to kill Officer Christopher McRae. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. And number two, the defendant did acts toward the commission of the crime of first-degree intentional homicide, which demonstrate unequivocally, under all of the circumstances, that the defendant intended to kill and would have killed Officer Christopher McRae, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone but the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside the defendant's control. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you were satisfied beyond a reasonable doubt that the defendant intended to kill Officer Christopher McRae and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed Officer Christopher McRae except for the intervention of another person or some other extraneous factor, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of attempted first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree recklessly endangering safety in violation of section 941.30 sub 1 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on your verdict to the charge of attempted first-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in section 941.30 sub 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree recklessly endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Number one, the defendant endangered the safety of another human being. Number two, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the law. Strike this. There's an error here. I will edit that out here. I'm not going to read it. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. And number 3, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Consider also the conduct after the act alleged to have endangered safety to the extent it helps you decide whether or not the circumstances showed utter disregard for human life at the time the act alleged to have endangered safety occurred. You are not in any event to find the defendant guilty of more than one of the foregoing charges. If you are satisfied beyond a reasonable doubt that the defendant committed attempted first-degree intentional homicide, the offense charged in the information, you should find the defendant guilty of that offense, and you must not find the defendant guilty of any other lesser included offense I've submitted to you. If you're not so satisfied, you must consider whether the defendant committed the lesser included offense of first-degree recklessly endangering safety. If you are satisfied beyond a reasonable doubt that the defendant committed first-degree recklessly endangering safety, the lesser included offense of count 2, you should find the defendant guilty of that offense. If you are not so satisfied beyond a reasonable doubt that the defendant committed either one of the offenses I have submitted to you, you must find the defendant not guilty on that count. Count 3 of the information reads as follows. The above named defendant on or about Thursday, June 26, 2025, at or near 2203 North 25th Street in the city of Milwaukee, Milwaukee County, Wisconsin, did recklessly endanger the safety of another person under circumstances which showed utter disregard for human life, contrary to section 941.30 sub 1 Wisconsin statutes. The defendant has entered a plea of not guilty to this charge, which means the state must prove every element of each count charged beyond a reasonable doubt. First-degree recklessly endangering safety, as defined in section 941.30 sub 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree recklessly endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. Number 1, the defendant endangered the safety of another human being. Number 2, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Number 3, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are not so satisfied, you must not find the defendant guilty of first-degree recklessly endangering safety. And you should consider whether the defendant is guilty of second-degree recklessly endangering safety in violation of section 941.30 sub 2 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on your verdict on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether the defendant is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in section 941.30 sub 2 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being. Before you may find the defendant guilty of second-degree recklessly endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant endangered the safety of another human being. And number two, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury is great bodily harm. You are not in any event to find the defendant guilty of one or more of the foregoing offenses. If you are satisfied beyond a reasonable doubt that the defendant committed first-degree recklessly endangering safety, the offense charged in the information, you should find the defendant guilty of that offense, and you must not find the defendant guilty of the other lesser included offense I have submitted to you. If you are not so satisfied, you must consider whether the defendant committed the crime of the lesser included offense of second-degree recklessly endangering safety. If you are satisfied beyond a reasonable doubt that the defendant committed second-degree recklessly endangering safety, the lesser included offense of count 2, you should find the defendant guilty of that offense. If you are not satisfied beyond a reasonable doubt that the defendant committed either one of the offenses I've submitted to you, you must find the defendant not guilty. The information alleges not only that the defendant committed the crime of first-degree intentional homicide in count 1, attempted first-degree intentional homicide in count 2, and first-degree recklessly endangering safety in count 3, but also that the defendant did so while using, threatening to use, or possessing a dangerous weapon. If you find the defendant guilty of any one of those counts, you must answer the following question. Did the defendant commit the crime of first-degree intentional homicide or the lesser included charge of first-degree reckless homicide in count 1, attempted first-degree intentional homicide or the lesser included charge of first-degree recklessly endangering safety in count 2, and or first-degree recklessly endangering safety or the lesser included charge of second-degree recklessly endangering safety in count 3 while using a dangerous weapon? That'll be a yes or a no. Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by the force of gunpowder. Before you may answer this question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using, threatening to use, or possessing a dangerous weapon and possess a dangerous weapon to facilitate the crime. If you are not so satisfied, you must answer the question no. Count 4 of the information reads as follows. The above named defendant on or about Thursday, June 26, 2025, at or near 2454 West Garfield Avenue in the alley in the city of Milwaukee, Milwaukee County, Wisconsin, did possess a short-barreled rifle contrary to section 941.28 sub 2 of the Wisconsin statutes. The defendant has entered a plea of not guilty to this charge, which means the state must prove every element of each count charged beyond a reasonable doubt. Section 941.28 of the Criminal Code of Wisconsin is violated by one who possesses a short-barreled rifle. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant possessed a rifle. Possess means the defendant knowingly had actual physical control of a rifle. You cannot look into a person's mind to find knowledge. Knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. And the second element is that the rifle was short-barreled. Short-barreled rifle means a rifle having one or more barrels having a length of less than 16 inches measured from the closed breech or bolt face to muzzle, or a rifle having an overall length of less than 26 inches. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. And third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. It's not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight you give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you're not bound by any witness's opinion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the results of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has an absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. The evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. The parties, we're going to take a quick break. So I think that is where we are going to end at this point. We'll just do a 5-minute comfort break, go back, use the restroom if you need to, tell anybody you're not coming for lunch plans, whatever it is, and then we'll get into the closings, okay? Please don't discuss the case amongst yourselves or with anyone else or do any outside research.
All right, so the 5-minute comfort break being given to the jury as opposed to a lunch break, which they have been taking at this time or right before things can. June 25th, they come up for the injuries, shooting injuries to Officer McCrae. First degree recklessly endangering safety for fire intent to kill. That his purpose was, his mental purpose for the charge of reckless in Milwaukee police in a brief reacted to kill.
All right, everybody, welcome back. The parties will now present their closing arguments to you. Mr. Huebner will go first, followed by Mr. Jones. Because the state carries the burden of proof, Mr. Huebner will have an opportunity to present a brief rebuttal argument. You may go ahead.
Can everyone hear me? Okay. Ladies and gentlemen, thank you for the last week. I know this has been trying. You have listened to, I think, approximately 35 witnesses. We've gone through over 300 exhibits. I've drank like 97 Diet Cokes. And what you heard was an absolute tragedy. I'm sorry you had to go through that. We have a little bit more to go through. Ladies and gentlemen, let's start off with the timeline. Amazingly enough, this entire incident, this entire tragedy, is due to a dispute between the defendant and his girlfriend. But that's what sets everything off. Everything happens because of that. We know that Tremaine Jones ends up finding out that the defendant is involved in a relationship with Tremaine Jones. Because of that, she kicks him out. Because of that, she says he can't be at the house anymore. A house that he knows who lives in. He knows there's small children in this apartment. It's a house that he had just been living at a day before. It's the house that he put on the paperwork in order to buy the rifle parts so he could make that short-barreled rifle. He knows there's a little kid in there. He knows there's small children in there. He knows that it's an apartment. He knows that there's tons of people because he got kicked out. That explains why there's so much stuff in his backpack. Like his entire life in that backpack. Jermella and Janira end up in a fight on June 25th. Janira's mad. She ends up Facebook messaging. She didn't know her name, but she knows her account. She ends up challenging Jermella to a fight. And Jermella shows up. But what does Jermella do? She doesn't engage in a fight. She brings friends. She brings a guy. She brings multiple people. And while she starts that fight, her friends finish it. As she described, and as Janira described, Janira got jumped. Now, keep in mind, it makes no sense that we're fighting over a guy who's cheating. Kicking him out makes sense. Fighting someone, but that wasn't enough for Jermella. She has to jump. And so the next day, there's another rematch, as it's described. Another group of bringing the people together. And what does Jermella do? She brings her friends again. And she says, for the thrill of it, that they're going to jump Janira again. But Janira has now Bryson Tyler. Mr. Tyler has a gun. And when a guy and girls try to engage in jumping Janira again, he breaks it up. He does not discharge his firearm. He breaks it up. And this makes Jermella mad. What does she call? Gun's been pulled out. Does she call the police? No. She calls the defendant. The defendant is brought to the scene. The defendant is called to the scene. He shows up and he brings this photo, as we see here in State's Exhibit number 320. An AR-15 rifle that he has put together. He's bought the lower receiver part a week before. He's bought the barrel part. This weapon is illegal. Its barrel is too short. Its overall length is too short. It's been made and is great for concealing. Without that buttstock and with that shorter barrel, this is designed as a weapon that is shorter in length. The defendant brings it. The defendant brings that, and he brings his backpack, which has his entire life in it. Visa, Social Security card, work ID, Social Security, or his birth certificate, and then also the paperwork that clearly identifies him as being the person that bought those parts. Put that gun together. He brings this gun to 25th and Garfield. He's wearing a Just Do It Nike windbreaker. He has a poo shiesty or some sort of ski mask over his head. You have seen the videos. You have seen the Ring doorbell. You have seen the cell phone videos that have been captured by numerous people. One of the most amazing things about this trial is that we are learning not only is there security camera, but people, when they're seeing fights or people, when they're seeing people with guns, are whipping out their cell phones and taking videos. Some because maybe they're going to tell the police. Others we know because they're putting it on Facebook for likes. And as weird as that may sound, thank God they did. Because those videos show the defendant. Those videos show the defendant when he shows up with that short-barreled rifle. They show the defendant when he's got that Just Do It jacket. They show him walking up and down 25th and Garfield saying, "Come outside. Bring it outside. I'll shoot your house up." Ladies and gentlemen, we know Alicia Moore calls 911. She is telling us and letting us know from the Ring doorbell camera, what we get from her house, as well as we get from video cameras from Markeisha Jones, that we get from Janira Jones. We get these particular videos, and they all show the same person. The person that everyone identifies as the defendant, that Irvin Toombs says is the defendant, De Janeiro says is the defendant, that James Johnson identifies both in the photo array and when he got up there and said, he looks different, but there he is. It's him, the defendant, with that weapon that he bought on 25th and Garfield. And we know, ladies and gentlemen, that at 9:10, he's there threatening to shoot the house up. At 9:13, we've watched that ring doorbell. At 9:13, the defendant, who's taking the backpack off and he's walking into the street, discharges that ring. In the later one, you can actually remember, we actually saw him kind of reach down by the curb and pick something up later in the second video. But on the first one, discharges that gun right there. On 25th and Garfield, he is discharging a 5.56 military type round. A short-barreled rifle that he designed. Outside a house that he knows his children in. In a neighborhood that he used to live in. An apartment building that he knows has someone's grandma. That he knows has old people and young people and everyone around. And he's just firing off a round in the middle of 25th and Garfield because he's just pissed because there's a guy in the apartment. And then he continues to threaten. And he continues to demand people to come out. And the 911 calls continue. From 9:14 to 9:26. You saw that 10-minute video that ends right before the final group of shots that happened on 25th and Garfield. You saw it. Marching up and down, gun in his hand, backpack on, backpack off, threatening people. The girl's trying to get everyone to come out to fight. I've never lost one of these fights, you heard him say. Come on or I'll shoot the house up. Problem is, as many times as Alicia Moore called, as many times as we heard Markeisha Johnson yelling at her kids, stay away from the window. District 3 is in crisis. They've just had a homicide. The officers are there. While those officers are there investigating that homicide, shots are fired. Officers have to go find that individual, remember? The tax squad has been deployed to help, and they're at a shooting. The Milwaukee Police Department is responding in any way they can. So 2 officers on the south side are sent. Officer Kendall Corder and Officer Chris McCrae. Officer Corder wasn't supposed to be working. And they get there and are dispatched. And when they arrive on scene at 9:31, ladies and gentlemen, I want you to consider what we saw from all the videos. We know that at 9:25 to 9:26, from those shot spotters that you hear, 2 more volleys of shots go off. We get 5 rounds and we get 1 round. What you could even hear, there was kind of a difference in the sounds of those shots. We heard that described by Jamela Kurtler, that she hears 2 different rounds. We hear from Urban Toombs that this is the defendant firing off rounds again, and we know from the casings inside there that this time Bryce Shine returns fire. He's shooting at a house that has kids in it, a kid that he thinks might be his. He's shooting again in this neighborhood. No regard for anyone's safety. Just his anger, his pissed offness that there's some guy at a house. And he decides to make the city of Milwaukee in the area of 25th and Garfield his little punching bag. This time someone fires back. Now we know, ladies and gentlemen, we know from listening from Mr. Toombs, and we know from Ms. Kurtler that they end up going down Garfield. And what was so important when we looked at that address, when we looked at that video, remember that kind of black and white video that was off by an hour, and we could end up seeing it's the video that ended up catching Officer Corder's death. We ended up watching a number of different videos they captured and showed us that corner of 24th Place in Garfield. Now the timing was off, but we know exactly when Officer Corder is shot and killed. We know that from the shot spotter, and we know that from the body cam. We know that that's occurring at 9:37 and 30 seconds, according to the shot spotter. When you look back and see how it's going, and you go back and take a look at those times, as we did, we are seeing that they are over at that corner at 24th Place and Garfield at approximately 9:29 to 9:30 to 9:31. That's when they're just kind of hanging up. You just see those kind of images in the background or in the corner. And the one individual we keep seeing hanging back is Mr. Toombs. Mr. Toombs, who just seems to be following it, like the little kid following the older brothers and trying to see what's happening. He's just following it and seeing it and trying to watch what happens. That, we know, ladies and gentlemen, is when they're around that corner, Jermella Kurtler sees a squad pull up. Officer Corder and Officer McCrae show up, and they have their lights off. He says, hey, that's the police. The next video, we now can see that by 9:33, the defendant, Mr. Toombs, Jermella, they're at that mouth of the alley. Remember, we actually saw the defendant who has that backpack, who's got that gun, who's got that ski mask over kind of the top of his head, is like kicking, remember, kicking the grass by the alley. Officer Corder has about 4 minutes to live in. Perceptions. Now we know from video camera footage, we showed you a lot, and you're probably wondering why we're showing so many different things that really don't seem to capture that much. But if you think about it, ladies and gentlemen, of that corner of that alley, we have the video camera that captures the mouth of the alley. It also captures right down going south towards Garfield, and it lets us see that. It also allows us to see what's happening going west and east. We can see what happens going east down towards 24th Street, and we know from that back video, 2 houses down, we can see the alley going west towards the original 25th Street and Garfield thing. We had video coverage of east and west and south. Only area we don't have is what's going on in that wood. The defendant goes to that wooded area. That wooded area that he describes to his mom as his place where he's just getting stuff ready in his bag. Where Mr. Toombs talks to him, he says, I'm going to post here. The girls, they go down east towards 24th Street. They go and get in an Uber. Mr. Toombs, he goes west. He goes down the alley. We see him on the video run, and then we see him coming back exactly like he describes. But the defendant is in that wooded area, getting stuff together just like he told his mother, sitting there with that backpack, with that gun, with that mask. At 9:37 is when Officer Corder and Officer McCrae placed themselves out of the corner. Ladies and gentlemen, it is important for us to watch this body cam. I have the exhibit in 3 minutes and 9 seconds. Keep in mind what we've just seen, what we know. Officer Kendall Corder and Officer McCrae have walked down this street. This corner's going to kill me. Now, this corner, when we're sitting here regarding this, ladies and gentlemen, they're at this corner. What is so important about what we're hearing is Officer McCrae told you that when they get to that corner, they're going to this corner because they saw people there. We know from the video that that's the defendant. We know that's Mr. Toombs. We know that's all the girls that went to go jump somebody because they can't fight a fair fight. We know that they're now looking for what they're fighting. They're looking for the guy with the AK, with the AR-15. They're looking for the defendant. They're looking for the defendant that everyone's taking a picture of. And where is he? As he's telling his mom in a jail call 2 days after this, I'm sitting in a spot getting my bag. Officer McCrae hears something.
You see that? See somebody? It's bouncing down there. Go to the floor. Yes. Go to the floor. You put us at 2 4 and right there.
I want you to consider exactly what we know. We know that they're there for a man with a gun. They're there for a man who's been shooting rounds. They heard someone talking about shooting. And Kendall Corder takes point. And he walks towards where they think an armed man is. And Officer McCray follows him. They have nothing but each other. They are two officers in an area they don't know on a day he's not even supposed to be there, and he answers the call. And this is what happens.
You see? You got the flashlight? You got 2 of them on. When he hit the alley, he straight to the left. I mean, he straight to the right, straight to the left. See?
And pausing at 4 minutes and 57 seconds. 16 shots, ladies and gentlemen. 16 shots of a 5.56223 from that rifle. Fired from a secluded, dark area. I want you to consider what you just saw and what you just heard. Officer Corder drops. We know because he gets around, comes in on the left side of his shoulder, goes to the right shoulder, and severs his spine. Severs it. He drops. He also takes one into the arm, and we know that he's getting some ricochet bullets towards his left. Actually, on the right side. So important is all his rounds are coming while he is facing in a front direction. He's dropping within the first 2 to 3 rounds. 13 more rounds go off. Officer McCray has already turned and is looking for cover. He is running for cover. And the defendant shoots 13 more rounds. Officer Corder is already down on the ground, 13 more rounds coming. Officer McCray is trying to find cover across the street, 13 more rounds coming. He takes one in the foot, he takes one in the leg, and thank God for his vest. That vest deflects the round that comes in on the right side of his shirt. You saw where that was. You saw where his injury was. That little graze wound after that bulletproof vest deflects that rifle round. It's right by his spine. They were shot at the head. Now I want you to consider everything we know. The defendant leaves his bag there with his entire life. He takes that rifle and he hides it by the bushes and kind of puts it in there. That rifle that has his DNA in the mixture on the trigger. That rifle that has definitely one of his fingerprints off of the tape and another one has all the same characteristics. This is the rifle he bought. This is the rifle he put together. This is the rifle he brings to the scene. This is the rifle that he leaves his fingerprints on, his DNA on, and he actually has all the documentation for in the bag that he leaves right there. And then he jumps the fence. And what's so amazing, what's so important, ladies and gentlemen, is I want you to consider the testimony of James Johnson. Not only did he identify the defendant as being the guy firing off rounds at 25th and Garfield, but after he hears those shots, he sees someone jump that fence. He sees that fence get jumped. He just says, I see the guy running south now. Can't tell you if it's the same guy. Doesn't have a gun, doesn't have a backpack. That's all I know. I just see a guy, he runs south. Why is that so important? Because, ladies and gentlemen, two things. The defendant's cell tower records showing that he is inconsistent with the area of the shooting scene. We know that from 9:31 all the way up to 9:36:45. That's going to be approximately 15 seconds before the officers put themselves out and go into that alley. The next contact we have is 9:39. That's after the homicide. He's moved, the phone has moved south. Who moved south? The man that jumped that fence. And what else is right by that fence? A Pushaisky ski mask. Ski mask that we saw the defendant wearing in every single video that was taken. Keisha Johnson's, Janira's, the Ring doorbell, that alley. See that mask. You saw the body. Two officers walking very close to each other. Just like he told his mom. He didn't have the body cam yet. We heard them talking about it. Said he's the only one that I saw there. When I left, he was the only one there. When I run in and talk to him, he says he didn't know it was the cops, just like he told his mom. Now, ladies and gentlemen, those are the facts. Here's the law. Counts 1 and counts 2 are first-degree intentional and attempt first-degree intentional. Counts 3 is the recklessly endangering safety for shooting at 25th and Garfield. Everyone has identified him as doing that. Everyone has identified him as shooting. He's showing utter disregard for human life. And everyone has agreed that he has this rifle, which is short barrel. So let's talk about 1 and 2. Number 1, the element is caused the death of Officer Corder, or, and it's actually the second element of attempt first-degree intentional homicide, did acts that would have killed Officer McCray but for the intervention of some other factor outside his control. It's basically the same element for both. He shoots 16 times. He shoots after Officer Corder's on the ground. He shoots after Officer McCray has gone for cover. He severs Officer Corder's spine. He definitely would have hit Officer McCray up around that area of the spine had it not been for that vest. His acts show that he is intending to kill. He uses a rifle he bought and made and brought. And now we get to intent to kill. And I understand that when the defendant is describing what he's doing, when the defendant is describing seeing those officers that he doesn't know are officers, seeing what's happening with these two individuals, he says it wasn't intentional, like he didn't know it was cops. We don't have to prove he knew they were officers. This isn't a killing a cop charge. It's killing a person. He sees two people. He tells his mom that. And he shoots them out of fear, according to what he tells his mom. He may say it wasn't intentional, ladies and gentlemen, but his actions show exactly the opposite. He wouldn't be the first young man to tell their mother, it's not as bad as everyone says. I didn't mean it that way, which is what he's doing when he's describing exactly what the shooter is doing. And what are his words to his mom? That's why my reaction was my reaction. As though firing 16 shots at an individual who's fallen to the ground and another who's running away is just a reaction. He shoots 16 times. He's intending to kill. It means you have the mental purpose to take a life, or you are aware that it is practically certain to cause death. And I want you to think about that barrage of shots, that volley of shots, that 16 shots. What is the one thing that you notice? There's that first group, there's a pause, and there's he's continuing to shoot. He pauses and shoots again. And that is why, ladies and gentlemen, the defendant is guilty of first-degree intentional homicide, an attempt first-degree intentional homicide. He killed Officer Corder. He knew it was practically certain. He was shooting at him until the man was not moving, and he continued to shoot at Officer McCray, despite the fact that the man was running away. And the only reason Officer McCray is not dead is because that vest did its job. If for whatever reason you do not believe that it is intentional, then we get to reckless. Cause death of Officer Corder or endanger the safety of Officer McCray. Criminally reckless conduct, utter disregard for human life. That is what's required in regards to those, ladies and gentlemen. When everybody else left the area, the defendant was in that dark spot. We know he can go through the cut between the two houses. We know he can jump the fence. He can do any number of different things, but he does not go anywhere. Stays there. Officer McCray hears talk of shooting because Officer McCray and Officer Corder are heroes. They go to investigate. And when those two individuals are walking down that street, close together, flashing their flashlights, just trying to get an idea of where this man might be hiding. Defendant takes a short-barreled rifle, points it at their heads and their bodies and their feet, and he lets loose with 16 rounds. That's why he's guilty.
Thank you, Mr. Huebner. Mr. Jones?
Well, I too want to thank you for your time and your attention to this case. It has been grueling and I appreciate it. Aristotle wrote that the law is reason free of passion. He didn't write is that that's not human. The human reaction in this case is obvious, right? The human reaction is to watch that body cam and be moved, be outraged, be emotional. The human reaction is to want justice in the way that we can answer it in a courtroom, and is to find somebody guilty. We want to blame. That's the human reaction. That's not the law. And unfortunately, that's not your job. The judge described the law to you and how you have to make this decision, devoid of passion, devoid of, unfortunately, a lot of those human instincts that we have around this case. What the law says is that if you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must find him not guilty. And I recognize that is clinical. That's detached. That's not the way humans function outside of a courtroom. But like we talked about at the very beginning of this case, we demand of jurors to follow the law and not function the way we do outside the courtroom, to apply that law to the facts as they were presented to you without the emotion that we all feel. So what's a reasonable hypothesis in this case, and what isn't reasonable? Let's talk about certain things here that I think would be unreasonable to contradict. This was his gun. right? That gun is his. He's guilty of possession of a short-barreled shotgun, no question. Tremaine Jones had that gun. It clearly is too short. It's actually, ironically, too short in two ways. The overall length is too short and the barrel's too short, according to Wisconsin law. He's guilty of that crime. He's clearly the individual that's walking up and down that street, yelling at these people that come in and come out, acting like a fool. Most everyone in this case is acting like a fool. So he's guilty of count 3. But I would tell you that I think he's guilty of second-degree recklessly endangering safety. That's a lesser included of first-degree recklessly endangering safety, which is what he's charged with. What's the difference between the two? And when you read the jury instructions, it's simple. The third element of first-degree recklessly endangering safety says that you show utter disregard for human life. Now, I think the state would argue that firing at a building, he said, I think 4 times with kids in it, that's not what the testimony is. He fired in the air. Mr. Tyler's the one that was returning fire at people. But he fired that gun in the air. That's recklessly endangering safety in the second degree. Find him guilty of that. That's what he did that night. What else would be unreasonable is to get up and say this isn't his backpack, right? It's his backpack. I mean, could you have any more identifiers in a backpack? It's got a social security card, a birth certificate, receipt for the gun, his name on a name tag. It's his backpack. So we have his gun, his backpack. But now we have a timeline. And the timeline here is what's important. The timeline is at 9:10 is when the first 911 call comes in. And then there are 4 more 911 calls at minimum that come in before police officers are even dispatched. I understand District 3 had a busy night. Officers eventually arrive at 9:31 and we have the shooting at 9:37. That's a 6-minute gap. A 6-minute gap where we don't see Tremaine Jones on video. A 6-minute gap where we don't know where everybody is. So, as jurors, when you have to look at the evidence critically, when you have to give the benefit of the doubt to the defendant, you have to look at that evidence through that lens and say, okay, what do I have to work with? Well, let's start with the physical evidence that you have to work with, and let's see if that helps you answer what happened in those 6 minutes. The DNA doesn't help you, right? The DNA's on the gun. Well, that makes absolutely logical sense, right? If he's firing it off earlier. His fingerprints are on the gun. Same thing. Now, the fact that there's no one else's DNA on the gun isn't really informative to you. It doesn't help you say, well, nobody else touched the gun, because you heard the DNA experts say DNA isn't always transferred on something. And she also said that the more you touch something, the more you handle something, the more likely is DNA will be on it. Well, we saw him parading back and forth with that gun for the better part of 20 minutes, right? From 9:10 to when police show up, I think he's off video around 9:28. So let's say 18 minutes, he's handling that gun, he's firing it in the air. But the fact, the absence of no one else's DNA on there doesn't exclude the fact that somebody else may have handled that firearm. The fact that there isn't fingerprints on that firearm besides Mr. Tremaine Jones, again, doesn't get you very far. Again, giving the benefit of the doubt, right? Asking yourself, it's reasonable. Is it reasonable someone could use that gun and not leave fingerprints? Guns are designed to not leave fingerprints. That's what you heard from the fingerprint analyst. That's why I asked that question. Does the cell phone data help you? Not really. At best, the FBI expert that came in here could tell you that it's basically 480 feet by a 720 feet radius, which is basically a city block. A cell phone's in a city block radius. Now, certainly the cell phone data supports the fact that he's at the scene, but we've already conceded he's at the scene. Cell phone data certainly supports that he goes up to where he was arrested. That's not in dispute either. So the physical evidence in this case, right? The fingerprint on the popcorn bag, well, it's in his own backpack. No one processed the backpack on the outside to see if someone else handled it, right? We don't have any physical evidence that lets you say, I know what happened in those 6 minutes, beyond a reasonable doubt. So let's go to the testimony, right? That's the next thing we'll consider, people's testimony. That isn't a lot of help for you either. Nobody, and we'll get to Mr. Toombs, but aside from Mr. Toombs, nobody testified as to what happened in that 6-minute window. Nobody testified as to where Tremaine Jones was in that 6-minute window. They said, certainly they talked about what happened before and the shooting in the air and everyone arguing to come out and fight. There's tons of testimony about that. There's only 2 people that testified about anything in that 6-minute window, and that's Mr. Toombs and Mr. Johnson. And if you look at both of their testimonies, they're inconsistent. And not only are they inconsistent, and I don't mean inconsistent in terms of, well, did they go left or did they go right? Are they wearing red or are they wearing blue? I mean, one cannot be true if the other one's true. Just can't. And Mr. Toombs' testimony just doesn't have any credibility. Now, I'm not going to try and understand Mr. Toombs' motives for why, when he's not involved, doesn't know any of these people, decides to videotape this, thinks it's a funny joke, then follows people around after shots are fired. Maybe he wants to be involved in something. Maybe he has some sort of, I don't know, complex that he wants to be part of the action. I have no idea. You don't have to speculate on that either. But here's what I can tell you. What he testified to that happened after the officer-involved shooting at 9:37 simply does not make sense. He's just wrong, especially in light of Mr. Johnson's testimony. What did he say? I know he got a little confused on the map, right? You look at Exhibit 1, he has his initials. First of all, he has it all the way on the east side, and he says, oh, no, I'm wrong, it's on the west side. What's critical about it being on the west side is what's between where he is on the west side and what he's seeing in the shooting is his grandma's house, just further west. But what he says is he's west there, he witnesses, at least sees shooting from the bushes, and then we do know that Mr. Toombs approaches the officers, right, to try and help, or at least he says to try and help. We don't know. We know that's true. The officer says, hey, stay back, because he doesn't know if he's a threat or not. Totally makes sense. Now he claims that then he backs up, not runs, backs up from the officers, full half block, and goes back to Grandma's house. And at Grandma's house, he happens to run into Tremaine Jones, who says, I thought it was other dude. That's a lie. It's just a flat out lie. Now, I don't usually call witnesses liars. I usually say maybe they're mistaken, but that just isn't true. How do we know that? Well, we know a few things. Mr. Johnson, right? What did he testify to? He said he sees someone hop the fence and head south, and they're running. Presumably the shooter. Well, if the shooter, right, is just involved, 16 shots, officers down, and you're booking out of there south, which the state says that's supported by the cell phone data, he's not going west towards Grandma's house. And he sure as hell isn't waiting around for the time that it takes Mr. Toombs to approach the officers, find out what's going on, and then back away. The shooter would have been long gone. We also, at no point in the video footage, don't forget, you could see 25th and Garfield from that Ring video footage, right? Did you see any Ring video footage after the shooting at all that showed Tremaine Jones back interacting with Mr. Toombs? The answer is no, because it doesn't exist. So now with Mr. Toombs, you don't have anything you can rely upon reasonably. You just don't. So you don't have this alleged statement that Mr. Tremaine Jones made that he thought, oh, I thought it was dude, or I'm going to be holed up in this area. Everything Mr. Toombs says is suspect. And I don't know why. And maybe he just wanted to insert himself into something that had, I don't know, some sort of media coverage attached to it, or he wanted to insert himself into this situation. I know he said in the Senate, I don't want to be here, and he was all quiet, but he wasn't quiet when he was videotaping, was he? He was laughing pretty loud. I don't understand Mr. Toombs, but what I do know is you can't rely upon his testimony. Certainly not in light of Mr. Johnson, who I thought was very credible. Said, guy took off south, jumping over a fence, which, by the way, also makes sense. What doesn't make sense is that someone like Tremaine Jones, who's never met Mr. Toombs, would take the time to stop and talk to him and tell him what he's doing after a shooting like that. So what else do we have? What else can you do to answer what happened in that 6 minutes? You have an exhaustive investigation here. What could have happened? What's a reasonable hypothesis that isn't inconsistent with the evidence? Is that Tremaine Jones, acting like a fool, shooting in that crowd, as soon as that, right, they know the police are coming, everyone scatters, dumps his gun, dumps his backpack, and takes off. There's nothing in the physical evidence, in the video evidence, and aside from Mr. Toombs, testimonial evidence that puts him there after the police arrive. Now, I'm going to sort of give you an analogy of what is a reasonable path, right? One of the things that my colleague, Ms. Ruckdashel, got up and talked about different ways to get to places, right? My wife and I work together, right? We've been driving to the same office together for years. And prior to GPS being on every single car, she always took a different route than me, and we always used to debate which route was the better route to work. Then GPS came out, right? CarPlay came out, and I was going to finally win a debate with my wife, right? So when I'm leaving home, right, I punch in Apple Maps, office, takes me, and guess what? It took my route. And I thought, this is it. I'm right. I'm finally going to be right. And then my wife, who tends to always be right, punched in Google Maps. But in Google Maps, she doesn't like taking the highway, right? She doesn't like any of the construction. So she says, avoid construction, avoid highways, right? In the morning, she likes to go buy her Starbucks, right? So she puts that in the route. And then it plots her route to the office. And it was the route she takes. Now that route takes maybe 10, 12 minutes longer, but it's reasonable. It's not the fastest. It's not the most direct. It's not the most obvious, but it's reasonable. Now, I only use that analogy to say, in this case, I understand that I have not proven to you in any way, shape, or form that someone else picked up that gun and fired those shots. I have not proven anything to you beyond a reasonable doubt. I don't have to. You just have to ask yourself, is there a reasonable alternative, and can I eliminate that reasonable alternative? Can I eliminate it as being unreasonable in light of the evidence? And I've shown you how the physical evidence can't get you there, and the testimonial evidence can't get you there. And we have this investigation that was exhaustive. And the one thing that is not in this entire exhaustive investigation is any video of somebody fleeing, the shooter fleeing the scene. Anywhere. It's reasonable that maybe the shooter hid in plain sight. Maybe the shooter approached the officers afterwards. Maybe the shooter hid out. Now, I'm not asking you to speculate. The state would probably get up in rebuttal and say, well, he's asking you to speculate. I'm not. I'm saying here's a reasonable alternative he needs to eliminate. Now, I know the state's going to probably get up in their rebuttal and talk about this jail call. Now, this jail call in isolation doesn't sound great. But remember, this is 5 days after he's been arrested. He's already made, according to the officer, about a dozen phone calls. This is one small snippet of context that the state is presenting to you. It's after he's had media reports saying what they think happened. It's after all of the allegations are now flooding in towards him. And I think one way of reading those jail calls or interpreting that jail call is he's explaining what they're saying happened. Thomas Jefferson wrote that the jury system is the only mechanism designed by man to anchor our government to the principles of our Constitution. What did he mean by that? What he's saying is the jury system is critical to our jurisprudence because we don't allow elected officials to decide cases like this, and we don't allow the government to decide cases like this. We bring people out from the community. And yes, we ask you to do something difficult. We ask you to remove sort of that human element I talked about. But we ask you to understand when we're making a decision this important, that we give that reasonable doubt to a defendant because that's what the community demands. Anytime you're going to convict someone of a homicide, something that serious. Now, the rest of that jury instruction I gave you about the reasonable hypothesis goes on to say, although you're to give the defendant the benefit of every reasonable doubt, you're not to search for doubt, you're to search for the truth. The truth here, when you apply the law as you're required to, is you cannot answer the question about that 6-minute gap. The truth is you don't have enough evidence to convict Tremaine Jones of the homicide or the attempted homicide. The truth here is that doubt lingers. And the truth here is that I'm asking you to do something that I recognize isn't in your normal human instincts. An acquittal feels like an unfinished story. Feels like we haven't answered the question. Guilty feels finished and resolved. It makes you feel good and human. But an acquittal is what's demanded of your duty as jurors. An acquittal on the homicide, an acquittal on the attempted homicide. I implore you to do your jobs. Thank you.
In rebuttal, Mr. Huebner.
Ladies and gentlemen, the defendant did not tell his mom the media says there were two guys close together. He says, I'm there putting stuff in my bag when I look up and I see two guys that look like they're from the neighborhood, people I don't know. I didn't know the cops were there. I see them and my reaction was what my reaction was. They pointed something at me. It definitely wasn't a flashlight. He's not saying, I think this is what it was, or this is what other people are saying. He's describing what he saw. He's describing what happens when he's in the back of that wooded area as two officers are walking. He describes it to a T. You've seen the video. His description is exactly what happened, and he didn't have it. They're talking about how he doesn't have it. He doesn't say someone else did. He doesn't say, Mom, I left my gun and my bag and my ski mask and gave them to someone else. He doesn't say any of that. What he says is, I'm there and I see two guys and my reaction was my reaction because he says he was scared. That's not saying other people. That's saying, Mom, I'm sorry, I just killed a cop. And that's why she's saying it wasn't intentional. Not I didn't do it. It's just not as bad as you think. Defense counsel is absolutely right about the reasonable hypothesis, but it is 100% about all the evidence. Think about that. He keeps saying 6 minutes. The only way you get to 6 minutes, ladies and gentlemen, is if you absolutely 100% ignore the video from 2217 on the 24th place. Why? Because that video, remember, it's the black and white, it's on the corner. It's the one that actually captures the officer's death. Why is that so important? Because that video shows the defendant in the alley. That video shows him right next to Mr. Toombs. That video shows him with his backpack. That video shows him by that wooded area. And it also shows that he never goes west, he never goes south, he never goes east. We also have the video from 2 houses down. What does that video show you, ladies and gentlemen? It shows you Mr. Toombs. Thank God he wore a white t-shirt that shows how easy it is to pick him out of that crowd every single time. You saw that kind of white area and that individual who's standing exactly where he pointed to on that map, standing there. And then you see the flashes, the muzzle flashes. Everything goes down and then he walks. Mr. Toombs is down the alley exactly where he said he was in that video. The defendant is exactly where Mr. Toombs said he was, exactly where he told his mom he was, exactly where he left his backpack, exactly where he left his weapon. The weapon he used to try to kill 2 individuals. Whether or not he knew they were cops or not doesn't matter. He fires 16 rounds, 13 of them at a guy who's running away. He takes a pause and he fires more. He severs a guy's spine and almost severs another and just says, "Mom, it wasn't intentional." I want you to consider something else. Mr. Jones says, well, maybe he left his stuff there. Video doesn't have him going east. Video doesn't have him going west. He disappears into that spot, exactly where Mr. Toombs says he is. Now, right, we don't have video that shows the southern area. We do have Mr. Johnson. Mr. Johnson says, after the shots, I see an individual run. He doesn't hit, jumps the fence. And what's at that fence line? His ski mask. It's the ski mask we were watching and seeing. That mask is right there. It's in water. It's covered in water. When the police get there, the torrential downplay has happened. But the mask that we have seen the defendant wear when he shows up, the mask when he's firing off rounds on 25th and Garfield, the mask when he's in that alley, that mask gets dropped. So in order for this reasonable hypothesis to occur, the defendant would have had to give his gun to someone else, to give his backpack to someone else, to give his ski mask to someone else, to somehow then stay within that block and then head the exact same way as the shooter, because that's the way his phone goes. And defense counsel says, oh, I can't believe anything Mr. Toombs says, even though everything he says is verified by the video, because he says that he's over by the area of 25th and Garfield when he talks to the defendant who says, I didn't know it was the cops. Keep 2 things in mind, ladies and gentlemen. When Jermella Kurtler is called back to that location to meet the defendant to bring him the change of clothes, where does she say she meets him? Area 25th and Garfield. What's the other thing? Mr. Toombs, who's talking to the police that night, says, he tells me he didn't know it was the cops. What does he tell his mom? He didn't know it was the cops. Mr. Toombs just somehow, according to Mr. Jones, wants to be a part of a media case, even though he had no desire. You could see his body reactions. He did not want to be here. That man somehow is able to guess what he's going to tell his mom 4 days later in a call. It's not reasonable. The evidence is very clear. The defendant shows up because he's mad about a guy who got involved in a fight between 2 girls that he's involved with. And we're also, remember, James Johnson, Mr. Johnson, who Mr. Jones, the attorney, stated he totally believes him, 100% honest. What does he say? Angle, shooting towards the house. Ladies and gentlemen, you're firing off rifle rounds, the sorts of rounds that can actually penetrate and get into a bulletproof vest. That's utter disregard for human life. The defendant fires 1 round and then he fires 4 more. Yeah, we don't have video of everybody coming back to 25th and Scott. We also don't have video of the exchange of gunfire, but defense counsel agrees that happened. So the simple fact we don't have video of it doesn't mean anything because he agrees we proved that. What do we have? We have video that's showing the shooter in this case stood in that tree. Backpack was ready to go. insurance is covered. The defendant tells his mom the entire story. He was seen. Ladies and gentlemen, the facts are clear. The defendant is guilty. The evidence is clear. Guilty. The verdict is clear. He's guilty.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. There are 11 different verdict forms. You will sign 4 total, 1 per count. Okay, I'm going to go through them now. As to count 1, one reading, we the jury find the defendant, oh, sorry, they're in the front pocket of the binder. That's where you'll find them. We the jury find the defendant Tremaine Jones guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Yes or no? Another reading, we the jury find the defendant, Tremaine Jones, guilty of first-degree reckless homicide, a lesser included crime of count 1 of the information. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of first-degree reckless homicide while using a dangerous weapon? Yes or no? And another reading, we the jury find the defendant, Tremaine Jones, not guilty of count 1. Count 2, one reading, we the jury find the defendant, Tremaine Jones, guilty of attempted first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of attempted first-degree intentional homicide while using a dangerous weapon? Yes or no? Another reading, we the jury find the defendant, Tremaine Jones, guilty of first-degree recklessly endangering safety, a lesser included crime of count 1 of the information. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? Yes or no? And another reading, we the jury find the defendant, Tremaine Jones, not guilty of count 2. Count 3, one reading, we the jury find the defendant, Tremaine Jones, guilty of first-degree recklessly endangering safety as charged in count 3 of the information. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? Yes or no? And another reading, we the jury find the defendant, Tremaine Jones, guilty of second-degree recklessly endangering safety, a lesser included crime of count 3 of the information. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of second-degree recklessly endangering safety while using a dangerous weapon? Yes or no? Another reading, we the jury find the defendant, Tremaine Jones, not guilty of count 3. As to count 4, one reading, we the jury find the defendant, Tremaine Jones, guilty of possession of a short-barreled rifle as charged in count 4 of the information. Another reading, we the jury find the defendant, Tremaine Jones, not guilty of count 4. Now comes the time where we select the alternate jurors. You have all been great, here every time, paying attention. Everybody has done everything that I've asked them to do, and I very much appreciate that. There are going to be 2 of you whose numbers I'm going to pull out. You've been renumbered. You came in as 1 through 40. You are now going to be known as jurors 1 through 14. I've got you renumbered here. I've got the list. I will reach in. There are 14 numbers in here. I'm turning my head and closing my eyes and pulling out 3, which I didn't see. It is juror number 5, Kaylee. That is our original juror number 15. On the renumbered list, you are 5, Kaylee K. All right. And juror number 6 on the renumbered list, that is juror 17, Paul K. All right. The 2 of you will be the alternates. I'm sure you have belongings in the back. You can go back when everybody else does. Gather your stuff. The deputies will bring you to my chambers and I will speak with you privately, okay? So just hang tight for a minute. This is a criminal, not a civil case. Therefore, before the jury may return a verdict, which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberation. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you've reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. You may swear the officers.
You swear or affirm that you will keep the jurors sworn in this trial together in some private and convenient place until they have agreed on and rendered their verdict or discharged by the court, and that you will not permit them to communicate with any other person regarding their deliberations on the verdict they've agreed upon except as authorized by the court. So help you God under the pain and penalty of perjury?
Yes.
Dun 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 dun. Dun 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 dun. What's up, JD? Dun 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 dun.
So
No
as you
word.
can see, the jury is now being excused to begin deliberations in the.
Okay, so they begin the deliberations at 12:35. Remember, they working through lunch. So the judge said, no, I want y'all just to deliberate through lunch. This shouldn't be that hard. This is not rocket science. So 12:35. So we have 1:45, 2:45. I'm assuming that court will go until maybe 4:30, 5 o'clock. They are 2 hours ahead of me. It's 11:30 here. So it's 1:30 there. So I'm thinking I got about a couple more hours if they don't reach a verdict just yet. I do have the stream up in the background so I can kind of keep an eye on it to kind of see where they're at. In regards to your question, Just Shamrock, no word on Zachary Adams, as far as I know. Yeah, this case is a wrap. Yeah, it shouldn't even take that long for this guilty verdict. They've been back there since 12:45. So yeah, I'm surprised they're not back yet. Shoot. You would have thought 5 minutes to guilty. Okay, so my question to you guys is, do we come back when the verdict comes in? Or do y'all want to rewatch any testimony in this case? Tell me how I can please you. Because I don't know. Like, I don't know if y'all want to rewatch any testimony or not until the verdict comes in. I know some people like to do that. I don't want to miss the verdict. That's what I do know. And I do think that
the way he did.
Let me see.
Certainly, that jail call was the words talking to his mom, and it was very devastating.
I did think it was interesting because the person in the white shirt, whose name we can't say, the witness who's 23 years old, who was following around all of this activity, who admitted he kind of thought it was exciting, who was saying I was going to post this video to Facebook, who actually told Tremaine Jones at one point, or at least claims he did, that he was going to be the lookout for the cops. He's the first one who approaches the officers right after 16 shots come out of the dark. At first, I thought they were going to try to point to him and say, well, maybe that's the guy that did it. I mean, he's the guy who shows up. How do you know he didn't have the gun? They never quite said that. But that seemed to be, maybe, was that a suggestion? Was that the hint that maybe it was this other guy?
Yeah, and I've mentioned a couple times during these broadcasts that a defendant is prohibited from specifically saying that somebody else committed the crime unless the judge pre-approves that line of testimony in advance. The judge did not approve that. That was never requested. So the defense attorney is left.
Okay, so we got a lot of requests in regards to replaying the girlfriend's testimony and anybody else's testimony that y'all would like to see. I'll be more than happy to replay. Probably hers, the stalker boy. I mean, because this was not like a long drawn out trial. Maybe the officer, the partner, that wouldn't be a bad one. That way we can just continue to hang until we actually get the thing in here. So let me get that testimony up and we can watch that again. Ooh. What day videos? Let me get that up. Yeah, because her testimony was only like 30 minutes. Like everybody's testimony was like really short, to the point. Very important testimony for all of them, but it was kind of short and to the point, everybody's.
Truth and nothing but the truth, so help you God, or under the pain and penalty of perjury. Please have a seat. Please state your first and last name and spell them both for the record.
Geneva Jones, Jeneera Jones.
Ms. Jones, you're fairly soft-spoken. You can pull that chair right up. You can pull the microphone to you. I'm going to speak loudly and directly into it because we do need to hear you. Everything's being recorded, okay?
Okay.
All right. Mr. Huebner, you may go ahead.
Thank you. Good morning, Ms. Jones.
Good morning.
I want to kind of talk to you about kind of some incidents that occurred in June of last year in the area of 25th and Garfield. Are you familiar with that area?
Yeah.
And in particular, I want to draw your attention to the building we see here in State's Exhibit number 126. You can also look behind you if that's easier. I know we don't have the best angles here, but you recognize that apartment building?
Yeah.
Did you live in that apartment building back in June of 2025?
Yeah.
How long did you live there?
For a year.
For a year? I'm trying to get that microphone right up there for you. And in regards to living at that apartment for about a year, who did you live there with?
Me and my kids in Maine.
In Maine?
Mm-hmm.
Is that a yes?
Yes.
Now I'm going to come back to who Maine is here in a little bit. But your children, how many did you have?
3.
How old were they?
1 and 2. No, that was 1 and 3.
And Maine, do you see this person, Maine, in the courtroom today?
Yeah.
Could you please point to him and describe him by what he's wearing?
Oh, he got on glasses and a dark blue shirt.
And can you let me know anything about what table he's at or kind of who he's sitting next to?
He's sitting next to a lady.
Michael?
Oh, right there.
He's got glasses. What's his hair like?
Twisties.
Kind of made the record reflect that the witness is identified and pointed to and described the hair of the defendant.
Fair.
All right. The record will so reflect.
You knew him as Maine?
Yeah.
What was your relationship with him?
That's my boyfriend at the time.
Boyfriend at the time?
Mm-hmm.
So yes?
Yes.
How long have you been together?
Probably for like, I'd say about 7 months.
And at the time, when this all occurred, did you believe he was the father of one of your children?
Yeah.
In fact, just to be very clear, that's been tested, right?
Yes.
He is not.
Yes.
But at the time, you thought he was, and he was your boyfriend.
Yes.
Now, I want to draw your attention to June 24th and June 25th. Okay, so the day before everything went crazy in the office, so the day before that.
Mhm.
Was there kind of an altercation that occurred at the street?
Yeah.
What started off this whole series of events?
The girl I fought called him the night before at 2 something in the morning.
Now, I want to talk to you a little bit about your relationship with the defendant. Was he living with you when this incident occurred?
Yeah. Yeah.
Was he still living there on this night of this occurred?
No.
Had you asked him to leave?
Yes.
Why?
Because we got into it, and he was cheating on me.
So when you're saying you got into it, you had got into an argument with the defendant?
Yeah.
And what about
Him cheating on me, and the girl calling him.
and her what?
Yeah. And the girl calling him.
I want to show you what has been marked.
Oh.
It's exhibit number 317. You recognize the person in state's exhibit number 317?
Yeah.
Who is that?
The girl I fought.
Is the girl that the defendant was cheating on you with?
Yeah.
Your Honor, the state would move state's exhibit number 317 into evidence in this time.
Any objection?
Yes.
No objection.
Received without objection.
So, I want to make sure I understand this. The day before the first fight, you had kicked the defendant out of the apartment.
Mm-hmm.
Yes.
Yes.
Because of the fact that he and this other person, do you know her name?
No.
This other woman were, that we see in 317, were engaged in a relationship he was cheating on.
Yeah.
That make you mad?
Yeah.
So, I want to talk about the first time a fight occurred. What happened?
I had text her. Yeah, asked her, do she mess with him?
Okay. And did anyone come over to your apartment?
Yeah.
What happened?
I told her to come to fight.
Okay. And then what happened?
They jumped on me.
Who jumped you?
Her and some girls and some boys she was with.
So some girls and boys jumped you?
Yeah.
What happened? Were you injured?
Yeah.
What happened?
Oh, they messed up my eye.
And in regards to you getting jumped that day in that fight, did eventually they leave?
Yeah.
I now want to talk about the night that the officers were shot.
Okay.
Did the group come back?
Yeah.
Who was all over at your apartment?
It was me, my friend, my sister, and my ex-best friend, and Brashawn.
Sorry?
And Brashawn.
And Bryce Sean.
Mm-hmm.
Who's your sister?
Tajada.
And who was your best friend?
Jamaria.
And was one of them dating Bryce Sean?
Sort of, kind of.
Who was dating him?
Miranda.
Sorry?
Miranda.
Miranda?
Yeah.
Now, at some point, why did you ask Bryce Sean or why does anybody ask Bryce Sean to come home to the apartment?
So I don't get jumped on.
Why? Did the group come back?
Yeah.
This woman that we see in State's Exhibit number 317, did she come? She came back with people?
Yeah, she came back with the same people.
Why did they come back?
Because they want the rematch.
And why was Bryce Sean there?
To make sure I don't get jumped on.
Make sure you don't get jumped on?
Yeah.
In fairness, did he have any firearms?
Yeah.
2 handguns?
Yeah.
Keep them in kind of a small little backpack?
Yeah.
Does a second fight occur?
Yeah.
What happened?
Oh, me and the girl fought. And they weren't trying to jump in and Rashida put the gun out.
So a guy was gonna jump in?
Yeah.
And Bryce stopped?
Yeah.
Did anyone shoot it?
No.
Then what happened?
I guess they called me.
And you're saying they, who's this?
The girl.
This girl here is 317?
Yeah.
Okay. Did you hear them make this phone call?
No.
So you're hearing some commotion, whatever happens, do you then go back inside your apartment?
Yeah.
And when you go inside your apartment, who's all in the apartment now?
Me, my sister, my ex-best friend, and my friend, Rashida.
And who's outside the apartment?
The girls, and May.
So Maine shows up,
Yeah.
the defendant.
Yeah.
When the defendant shows up, what do you notice about it?
He got a book bag.
Yeah, what?
A book bag.
Book bag?
Yeah.
Big book bag?
Yeah.
Okay. What else does he have?
A gun.
A gun?
Yeah. Yes.
I want to show you what has been marked as State's Exhibit number 263. Recognize this?
Mm-hmm.
Yes?
Yes.
Whose gun is this?
Maze.
Maine's?
Yes.
Now, when the defendant shows up with this firearm, what's he doing out there? Need a moment? Yeah, it's okay. You take some time.
There you go. I can put on my glasses. Okay.
Let's go to the sidebar, please.
Sure.
There is a so, ma'am, sorry, I thought you normal eyeglasses. I need you to take those off.
Oh, Lord.
Oh, it's okay.
They don't see me cry.
It's okay. All right, if you need a moment to compose yourself, that's okay. All right. Now, what's the defendant doing while he's outside?
Walking back and forth.
He's walking back and forth?
Mhm.
Is he doing anything while walking back and forth?
Yeah. Well, he got the gun in.
I have State's Exhibit number 152 in the computer. A moment. And within the computer, there is a folder entitled Photos and Video Downloaded. And within that particular folder, I have a video entitled _7022 Move, which should be coming up on the screen as we speak. Ma'am, you familiar with this video?
Yeah.
Whose phone did the police get this off?
Mine.
And is this video a fair and accurate depiction of what you saw someone doing outside your apartment?
Yes.
Who's the person we're going to see in this video?
May.
The defendant?
Yes.
Okay. And to be clear, did you take this video?
No, my ex-best friend.
But this is what you're seeing while you're with her?
Yes.
Your Honor, at this time, I would move the video that I'm about to play on State's Exhibit number 152 in evidence at this time.
Any objection?
None.
Received without objection.
And playing from this portion. Who was that individual we saw with the weapon, kind of the thing on his hair or on his head and that jacket?
Man.
Is that it?
Yes.
One moment, Your Honor, I apologize.
No problem.
Now, and at some point, do you call 911?
Yeah.
Why are you calling 911?
Cause they say you're gonna shoot up my house.
Why was the defendant threatening to shoot up your house?
Because Barcelona's in my house.
Because there's a guy in your house.
Mm-hmm.
Is that a yes?
Yes.
The defendant was outside with this weapon.
Yes.
What, telling Bryshawn to come on down?
Yes.
Okay. Your Honor, I am now placing State's Exhibit number 3 back in the computer. 1 minute. And now we'll be playing for the record calls 2 and 16 from this particular CD that have not previously been moved into evidence. I would move them into evidence at this time.
Any objection? Received without objection.
And just bear with me, the first part's always a little loud, but then it comes back down. Playing from that portion.
There's a boy at my house with a gun, and they keep coming to my house trying to fight. What's the address? 2203 North.
That's not me.
That's not you, but is it going to be one of the women that are in your house?
No, they don't sound like neither one of them.
One moment. And I'm going to play just a little bit more, and I want to see if you recognize some of the descriptions being described in this call, okay?
Okay.
Your Honor, object, she indicated she doesn't know the voice on the 911 call. She indicated it's not her.
Your Honor, if I may, it's going to have the apartment number and her name.
All right, I'm going to allow it. Well, I'm going to see parties and chambers. 1 second.
It's a little bit of an unexpected moment right there. And
Thank you. You may go ahead, Mr. Huebner.
Thank you. One moment while we wait for the computer to fire back up. And I have it currently at 3 seconds into the recording. I'm going to play from this portion.
That's my house with a gun, and he keeps
coming to my house trying to fight.
What's the address?
2203 North 25th Street.
Okay, repeat that for verification.
What you say?
Repeat it for verification.
2203 North 25th Street.
Okay, is it a single family, apartment, or duplex?
Apartment.
Okay, what unit?
2.
And do you know him?
He out trying to Cyrus off to get him arrested because he already blacked my eye and I don't.
Okay, what is he wearing?
He got on the what he got on, y'all? He got on the.
That do sound like me. I'm sorry, what did you say?
Okay.
I didn't hear what you said.
I don't know. Ma'am, can you repeat what you said?
I think that is me.
Okay,
She said, I think that is me.
so sometimes hearing the recordings of your voice, you might be shocked to find out what you sound like.
Yeah.
And I find out that I'm very nasally, and I'm very shocked by that. But in terms of what we're hearing, this is you calling 911, is that correct?
Yeah.
We talked about your eye being black. Is that right?
Yes.
That's from the prior fight when you got jumped.
Yes.
And the boy who is outside your apartment number 2, who is that?
Maine.
Okay, that's the defendant?
Yes.
Okay. Playing from this portion at 43 seconds into the recording.
A Nike jacket.
Okay, what does he have dreads or not?
What's his jacket? Y'all shut up. Can you repeat that?
Does he have like long dreads or no?
No, he got a low cut. He got a ski mask on.
Pausing at 1 minute or 1 minute and 1 second. This individual you're describing, you're stating he doesn't have dreads, but he's got like a ski mask on. Is that fair?
Yes.
Over his head.
Yes.
Okay. Now, continuing to play from 1 minute and 1 second.
It's over his head.
Okay. You said he has a low haircut?
Yes.
In black clothing, all black?
Yes, with some Crocs on.
What color Crocs?
No, he got some dunks on.
Oh, dunks. A black ski mask?
Yeah.
Ma'am, I already have the call entered. It's not delaying anything. Is he black, white, Hispanic?
He's black. Talk to him.
What's his name?
Tremaine.
Pausing at 1 minute and 50 seconds into the recording. We can hear there's a number of different voices regarding this call, right?
Yes.
There's you, there's your friends,
And my sister.
and your sister. The name you just talked about with this boy that's trying to come inside your house and has a gun outside and the ski mask above on his head, who is that person?
Maine.
You identified when you hear his name, Tremaine, in the call?
Yes.
That's the defendant you've identified?
Yes.
Playing from 1 minute and 50 seconds into the recording.
And how do you know him?
Baby daddy.
Pausing at 2 minutes and 11 seconds. We can kind of hear the background, bring them outside. Is that fair?
Yes.
Who was that we heard screaming in the background?
Maine.
The defendant?
Yes.
Playing from 2 minutes and 12 seconds into the recording.
He outside. He said he's threatening. He just shot.
He shot in the house?
Yes, he just shot a bullet to the house. You gotta hurry up. Like, what the buzz? They had to get here ASAP. We just do that motherfucker. Get here.
Pausing at 2 minutes and 37 seconds into the recording. Did you hear gunshots?
Yes.
Where did you hear them?
Outside my window.
Did you, in fairness, did you see who shot?
No.
Who was the only person you saw with a gun outside your house?
May,
Were you scared?
a little bit.
We can hear you begging the police to get here as soon as possible.
Yeah, yes.
Okay, now. Got it. Now moving to call 16. Moment as the computer gets fired up. And call 16, and we've already moved that into evidence.
Yep.
Playing from this portion at 1 second into the recording.
Hello, caller 911. Where's your emergency? Where are you located? Caller, where are you located? Do you need help? Come on.
Hola, está llamando a la familia Gandía Morales. Favor dejar su nombre, su número de teléfono, su mensaje y luego se le devolverá la llamada. Gracias.
Was a call from your number?
It was.
Did you hear kind of the voices? Was that any of the kids?
I think so.
But you're not sure.
I'm not sure.
The first one, though, describing the shots and all of that, that was.
Yeah, that was me. Yes.
Now. Ma'am, the shooting's happening outside your apartment. What happens next?
My mom pulled up to get my kids. And we go outside.
Did you hear other shootings outside?
No,
Did you ever hear the shots in which the officer was shot?
no.
When the shooting's happening outside your apartment, I want to kind of focus in on that portion of it. Where were you?
Inside the house,
Where inside that?
in the back room.
Why'd you go to the back room?
Because he shot through the window.
Where was Brett Sean?
In the living room.
Did you see Brett Sean return fire?
No,
Do you know if Brett Sean returned fire?
no.
He could have thrown you.
Yeah,
The shots from outside, did they occur first?
yes,
And that's why you ran to the bedroom?
yes.
Did the police eventually arrive at your apartment?
Yes.
They ended up getting a search warrant, is that fair?
Yeah.
Were you willing to let them search, or did they ask for a search warrant?
No, they already searched before the search warrant.
Now, ma'am, you don't know what happened to the police officer.
No,
You didn't see that.
no,
You weren't there for
no.
that. All you know is about this fight that occurred the day before, the fight that occurred the hours before, and then who was outside your apartment with a rifle trying to get Brett Sean to come out.
Yes.
Who was that person?
May.
The defendant? The defendant?
Yes.
Thank you. Cross?
Thank you. Ms. Jones,
I think you said 2 days or so before this shooting, you kicked Mr. Jones out of your house, yes?
Yes,
And that's because you believed he was cheating on you, yes?
yes,
Okay. And you said you don't know that person's name that he was cheating on you with, yes?
yes,
But you identified her at, I think, Exhibit 317, yes?
yes.
Okay. You don't know her name, but you said you texted her, yes?
Yeah, I know her Facebook name.
Okay. You know her Facebook name, okay.
Yeah,
So but you had the phone number of someone whose real name you didn't know.
I didn't.
Him, you meant Tremaine.
Yes,
And she said yes?
yeah, and she said some other stuff too.
And then you said, come on over here, let's fight.
Yeah,
Okay. And again, this is the night before, right? The 25th?
yes,
That's the night that your eye got all black.
yeah,
And on that night, Tremaine wasn't there,
he wasn't there.
just the girls.
Yes,
Okay. And then the next night, this person whose name you don't know came over again.
yes,
Got it. And when they originally got there, Maine wasn't with them.
no,
At some point, Maine shows up.
yes.
You don't know how he got there?
The girl called him.
The same girl that he was cheating on you with?
Yes,
How do you know that?
because she was the only one that was out there. Him and and his cousin.
Okay, so you actually don't know that for a fact, but that's what you assume.
Yeah,
Okay. We just listened to 2 911 calls. You remember that?
yes,
The second one kind of doesn't have any talking, right? It's just sort of emptiness.
yes,
Okay. I'm asking about the first one. Does that make sense to you?
yeah,
Okay. The first one, you specifically asked them something along the lines of, come get him arrested. Yes?
yeah,
And then you said, he already blacked my eye.
yeah.
But did you just say he wasn't there for that first fight when your eye got black?
No, yeah, he wasn't, but he was there the morning of the first fight.
Okay. But my question is, I'm confused. You told the cops on 911, this man blacked my eye.
Yeah,
Okay. But that wasn't true.
some of it wasn't and some of it was.
Okay. So you lied. Got it. Isn't it true that you went to the police station, I believe it was that next day, Friday the 27th, yes?
No, I went to the police station the night that the police got killed.
Okay. At some point you were at the police station and you sort of gave a statement. Does that make sense?
Yes,
I'm not insinuating that you were arrested or anything. You just went there willingly, yes?
yes,
Okay. And you remember talking to Detective Martin and Detective Casey?
yeah,
Okay. Isn't it true you told them you didn't know Bryshawn's name?
I never told them that.
Okay. If it said in the police report that you did know his name, or strike that. If it says in the police report, you said you didn't know his name, that's not true.
That's not true.
So you're saying the police report's wrong.
Yeah, I knew his name.
Next question. You told us today on the stand that you knew Brayshawn kept guns in a backpack, yes?
Yes,
In that interview with Detective Casey and Detective Martin, it says in the police report, you said you didn't know he had a gun. So are you telling the truth today or were you telling the truth then?
Argumentative. You rephrase your question,
Yes.
please.
Is your testimony today that the police report's wrong?
yes,
Your Honor, she has not seen the police report. That's hearsay. She needs to simply ask her if she said it and then introduce another witness. That's how it's.
Sustained.
Did you tell police that you didn't know he had a gun?
I don't remember.
You don't know, okay. Did you testify today that you did know he had a gun and you kept him in a backpack?
Yeah,
Okay. At some point, police searched your house, yes?
yes,
Were you there for that or did you leave?
I left.
Okay, so you don't know what they found?
No,
Okay. On that night, you said you were in the back room, fair?
yes,
So you don't know if anyone from your house returned fire?
no,
Okay. You didn't hear it?
no,
And eventually, you sort of heard through the grapevine that some officers had been killed, yes?
Yes.
You didn't witness that?
No.
You didn't hear that?
No.
Got it. Thank you.
Any redirect?
No, thank you.
All right, thank you. You may step down. You're all done.
So that was the
Okay.
last
All
person
right,
that they
ladies and
saw.
gentlemen, it's about 11:45. I'm going to send you for lunch.
So there go the spicy girlfriend. She's all spicy. She said, let me tell it like it is. Okay, now let's get let's go. They are still deliberating, guys, just so y'all know. I haven't seen anything come back. And let me see. And it's 8 men and 4 women. They do have that on their thing. They did say that. And so they are still deliberating. Let me put this on a different screen so we can see that. And because then when I click off that screen, for some reason, it seems like it pauses it. So I put it on a different screen. Let me get up.
It's easier than trying to lean forward the whole time.
Let's do this testimony from oh boy, and then we'll go into the testimony from the other ratchet yesterday. Yeah, I didn't think I didn't think she was a liar either, SD. I mean, it sounded like she remembered what she remembered, and she just telling it how it is. The timestamp of his jail call. You talk about in regards to listening to his jail call that we watched earlier. No, I don't, but I know it was with the last witness, if that helps you. So it was with the last witness, and no, because I haven't wrote any of that stuff out or clipped it. Yeah, I haven't wrote any of the stuff out or clipped it, and so yeah, I probably can't tell you. I'm not probably a good one for that one. I would just say I know it was the last witness before we went into closing argument, jury instructions and closing argument. So it wasn't that far into, because we only had 2 witnesses today.
There you go.
Please state your first and last name and spell them both for the record.
Urban Toombs.
Good morning, Mr. Toombs. Now, I have a couple questions I'd like to talk to you about. Sir, I want to draw your attention to an incident, a series of incidents that occurred in June of last year. Were you present for some things that occurred on the area of 25th and Garfield?
Yes, sir.
How were you familiar with that area?
I was staying there with my grandma.
You were staying with your grandma?
Yes, sir.
Okay. I'm just gonna kind of get that microphone there for you the best I can. Now, I'm gonna kind of show you, first of all, we have a Google map in terms of what we're referring to here, and we're gonna zoom out just a little bit. So if we can see kind of, can you see the map where you are? Let me move this screen so everybody can see it best we can. If we're going to be looking kind of in the area of, let's make sure.
Just hold on just 1 second here. I can't quite see the witness. I know, so we're trying to position the court reporter, so.
Okay. She can't move. It is. Can you pick your chair up and just kind of bounce it over a couple of spots? Better? All right. Thank you.
Thank you.
Okay, now, just returning to where we were, we're going to be kind of discussing, you okay, sir?
Yeah.
Okay, we're going to be discussing what we're looking at. We can see Garfield, 24th, 25th. Is there kind of an apartment building on the corner of 25th and Garfield that you're familiar with?
Yes, sir.
And is that where your grandmother lived?
Yes, sir.
Okay. Now, were you staying with her at the time?
Yes, sir.
I want to kind of draw your attention to a series of fights that occurred out in the street. I want to talk about the day before the officers were killed. So the day before. Are you familiar with anything that occurred kind of in front of that residence?
Yes, sir.
And what did you see?
I seen a group of girls outside. And
I can't hear you.
I seen a group of girls outside, and they were arguing with the girls that was standing upstairs from me.
Now, sir, are you nervous?
Mm-hmm.
Is that a yes?
Yes, sir.
You don't want to be here, do you?
Not really, no.
Okay. Gonna be okay. Just calm down and try to speak up into that microphone, okay?
Okay.
Now, I want to draw your attention to State's Exhibit number 117. If we're looking here at 117, and I'm going to zoom out a little bit so we can kind of see what we're talking about here. And move it up. Do you recognize this intersection that we see here?
Yes, sir.
Okay. This building that we're looking at in terms of here, is that the building that you were staying at your grandmother with?
Yes, sir.
Now, I want to show you what has been marked as State's Exhibit number 126. You recognize that building?
Yes, sir.
What building is that?
That's my grandma's house.
Now, is it an apartment building?
Yes, sir.
And did your grandmother, did she live on the bottom floor or the top floor?
She stayed on the bottom.
Now, you mentioned girls that kind of lived above you. Is that fair?
Yes, sir.
Did you know them?
No, sir.
I mean, had you seen them around?
Yes, sir.
Did you know if there was ever a guy that was up there?
No, sir.
Did you ever see a guy that kind of hung out with them?
Yes, sir.
Do you see that person in the courtroom today?
No, sir.
You eventually see a person that comes over to the residence with a gun.
Yes, sir.
You see that person in the courtroom today.
No, sir.
Could you please stand up and look around? You see him?
Mm-hmm. Yes, yes, sir.
Did you ever see him by that upstairs apartment as well?
I seen him probably like twice.
Could you please point to him and tell me where he's wearing, what he's wearing?
He wearing the glasses and the shirt.
Glasses and a shirt?
Yes, sir.
Okay, does he have a tie on?
No, sir.
Can you describe what his hair is like?
It's like twisted.
Like a little twisted?
Yes, sir.
Can you point to him for me, sir? Your Honor, may the record reflect that the witnesses both pointed to and described the defendant.
Any
I
objection?
think that's accurate, Judge. I do need to keep this volume up. Though.
Yep.
I'm not.
I understand. The record will so reflect, Mr. Toombs. I know you're nervous. I know you don't want to be here, but we don't want to have to prolong it by having to ask you to repeat everything. If everybody can hear you, just feel free to use your best outside voice and speak up, okay?
Yes, ma'am.
Okay, thank you. Go ahead.
Okay, now, I want to get to before the defendant's showing up. I want to stay on that first fight that occurred the day before. How did you see it? Like, how's it come to your attention?
I had just came from volunteering. I think I got dropped off, and when I got dropped off, it kind of was going on. Everything was taking place.
You said it was going on.
Yeah, it was like everything was going on. Like,
What's going on? What are you seeing?
girls arguing. Yeah, girls was arguing.
Were they fighting?
Not at the time, no.
Do you eventually see a fight that night?
Eventually, yes.
And can you describe the fight?
They was just fighting.
Did you stay outside to watch it?
Yes, sir.
Why?
I was curious.
Did that fight eventually end?
Yes, sir.
Where did all the girls go?
Wherever they went, they went their own way.
Now, I want to draw your attention to the night that the officers were shot and killed. The officer was shot and killed, another officer later. Were you present for the events that occurred that night?
Yes, sir.
Was there something that, before we get to the shooting of the officers, I want to talk to you about kind of the events leading up to that. Were you present for the initial confrontations between girls?
Yes, sir.
How did you come across this? What brought it to your attention?
It kind of just played out how it did the first time. Yeah.
Where were you when you're seeing this confrontation between girls?
I was by my grandma's house, like right on the side. Like I could see everything.
Kind of in that little front porch area?
Yes, sir.
And so if we're looking here on the house residence, we're kind of talking about this area where we can see stairs and doors and things like that?
Yes, sir.
Okay. And where was the fight occurring?
Kind of like in the street.
Now, this second fight that occurs, the girl that lives above you, did she have a guy with her this time?
Yes, sir.
And while you're kind of watching this altercation, do you take any videos with yourself?
Yes, sir.
Why'd you do that?
I was gonna post it.
You're gonna post it?
Yeah. Well, I was gonna send it around. Yeah. Post it. Yeah. Show people. You know.
I can't hear the answer, Judge.
I was gonna post it and like send it to people that I knew. Stuff like that.
About girls fighting?
Mm-hmm.
Is that a yes?
Yes, sir.
Maybe it would be easier if you pull your chair up a little bit more. There you go. Thank you.
Okay. Now, Your Honor, I have State's Exhibit number 124 back in the computer. There is a folder entitled Video from Urban Tombs. Within that folder, there is a single audio-visual file that I am going to be opening with DLC Media Player. I will be playing and moving this video into evidence at this time.
Objection.
All right, received without objection.
Can you see the area and the video?
Yes, sir.
Did you take this video?
Yes, sir.
Is this the video from kind of the first fight that happens between the girls on the night of the shooting?
Yes, sir.
And I just want to kind of, what we're talking about here, we can see what appears to be what? It's kind of light out. It's not as dark as what we're going to be talking about later. Is that fair?
Yes, sir.
Okay. We can see here appears to be one group of females. Is that the group that lived above you?
Yes, sir.
Now, I'm going to be playing from 0 minutes and 0 seconds into the recording. Pausing at 7 seconds. We can hear someone laughing. Is that fair?
Yes, sir.
Who was that?
Me.
And I want to draw your attention to kind of two different areas of the video. If we're looking kind of down the block, you can see 25th Street, you see the apartment building. Do we see kind of in the I guess in the distance, that other group of girls that was involved in this argument or fight?
Yes, sir.
Now, I want to draw your attention to another individual. It's going to be this individual that we see here. See, he's got black top, some long dreads, red shorts. Was he associated, was he this male that was associated with the group that lived above you?
Yes, sir.
Do you know who he is?
No, sir.
Are you going to notice anything about this individual?
No, sir.
Did he appear to be armed with anything?
Oh, yes, sir. He did.
What did he have?
He had a handgun.
And going to tools and filters, effects, video effects, geometry, interactive zoom, and moving over. Playing for a little bit, from 7 seconds into the recording. Pausing at 15 seconds into the recording. This individual that we're seeing, he appears to have kind of like a small backpack on his front. Is that fair?
Yes, sir.
And we can see what appears to be kind of a magazine of a firearm or a handgun in his short spot, or in his waistband or something like that. Did you see him at this or during the fight between the girls ever pull the gun out?
Not to my knowledge, no. No, sir.
Did you see him intervene in the fight in any way?
No, sir.
Now, going back from effects and filters, going out of the interactive zoom, closing. I'm going to play the remaining portion of this video from 15 seconds.
Wait, get your messy ass on. You so irritating.
Oh, the G that's going on Facebook.
Go, come on.
Oh my God.
You didn't know that. They did. Got that eye. That nigga got that eye. You didn't know it. You didn't know it. You didn't know it. You got that eye. You cracked in my eye. Yeah, you did. This is what you did. You really did. Oh, my mama. She made you let her get that. Yeah, that's why I kicked you. Yeah.
And pause 59 seconds into the recording. Is that a fair and accurate copy of that video you took?
Yes, sir.
Now, does the group with the guy with the short guy with the dreads and shorts, red shorts, does that group of girls, do they stay outside or do they go back up into the apartments?
They eventually go in. They didn't stick around.
What about the other group of girls?
They kind of was just out there, like hanging out. Yeah, they said they wasn't leaving.
Okay, they said they weren't leaving?
Yeah.
At some point, do you see them joined by any individual?
What's me?
Fair enough. Bad question. Does anyone join that other group? Does anyone show up?
Later on, yes.
How much later?
Probably like an hour later. Not even, yeah, I want to say like an hour later.
Who's this person that shows up to join that other group?
I guess I don't know who he is to them, but
You don't know his name.
I know who he is. Like,
Is that the guy you already identified in court?
yes, sir.
But you don't know his name, or you didn't know him like that?
I didn't know him like that. No, sir.
Do you know how he's associated with the other group of girls that stayed around outside?
No, sir.
Now, when the defendant shows up and is kind of with this other group of girls, does he have anything with him?
Yes, sir.
What?
A long barrel rifle.
You have a rifle?
Yes, like a big gun.
Big gun?
Yes.
Was he wearing anything on his back?
A book bag.
And what's the defendant doing?
It was trying to get the guy to come outside.
How's he doing that?
He was walking around, pacing around. He was yelling, "Come outside. Come outside."
Now, do you go into your grandmother's house, or do you kind of still stay out?
I was kind of still on the porch, like watching everything.
Why are you watching?
I was curious.
Guy shows up with a big rifle, you continue to watch.
Yes, sir.
Now, at some point, while the defendant is outside in the street with this rifle, do you see him ever do anything with it?
He shot it in the air a few times.
Now, Your Honor, remaining on the same exhibit.
Okay.
124, same video exhibit, the flash drive. Now going to the video folder entitled Alicia Moore Garfield Video folder. There are the two videos we've already talked about, beginning and going to the first video that ends in 103521, opening with VLC Media. And going to effects and filters, video effects, geometry, interactive zoom. We're going to kind of focus in on the area that we're talking about. Placing it on the big screen. Do you recognize the area that we see here, sir?
Yes, sir.
And when we're kind of watching this video and kind of seeing this area, is this that other group of girls that kind of been hanging out there for a long time, trying to get someone to come out from outside that apartment?
Yes, sir.
Now, I want to play, while this is happening, you indicated that you were hanging out where?
On my grandma's porch.
On the porch?
Yeah. It's like a ramp.
The ramp?
Yeah.
So if we're talking about kind of, would this be this area that we can see with the stairs and the front porch area and then the ramp in the front?
Yes, sir.
And just gonna go back so we can kind of take a look at 126, so we can see the area that we're referring to. Are you referring to kind of this area that we see right here?
Yes, sir.
Now, before the shots, while the defendant is kind of in that area with that rifle, does he ever talk to you?
Yes, sir.
What does he ask you?
He said, did I see anybody? Did I see another dude?
Did he
Did I see anybody with a gun?
see anybody with a gun?
Yes, sir.
Playing from 0 minutes and 0 seconds into the recording. Pausing at 10 seconds into the recording. This individual that we see here with the rifle, is that the defendant?
Yes, sir.
And does he come and talk to you and ask you whether or not you saw anybody with a gun?
Yes, sir.
Playing from 10 seconds into the recording. Pausing at 37 seconds into the recording. The video shows the defendant kind of going over by the area of where the porch or the front area is and pointing up. Is that fair?
Yes, sir.
Is he talking to you at this time?
Yes, sir.
If you remember. Now, playing from 37 seconds. Pausing at 53 seconds into the recording. Did you see him shoot into the air?
Yes, sir.
Was that the defendant saying, bring it outside?
Yes, sir.
Did you continue to stay out there and watch?
Yes, sir.
Why?
I was curious. I wasn't trying to go in the house.
Your Honor, staying on the same exhibit in the same folder, video folder, now going to the second ring video in the Alicia Moore video folder.
Okay, I got a question. Can I try something with you guys? I'm trying to see if this works. So I am trying to, I'm sorry, I paused it right there. So what I am trying to do is see if I create a room and I want to redirect you guys. Like if I want to redirect you guys, I'm trying to see if I can redirect you. You know how typically I would drop the link in here and be like, okay, everybody, we moving over to such and such room. I am trying to see if I am able to redirect you guys. So give me 1 second. Let me see if I can redirect you so I no longer have to like drop those links while we waiting for some downtime in regards to this case. Give me 1 second. What am I doing? What am I doing? Okay, here. Because I really want to see if this works, because this is what I would like to do instead of always giving y'all new links. You know how we always in everybody courtroom being so dang on nosy. Even though giving y'all the links is not really like a big problem, but if I can move you guys without you having to move yourself, that would be awesome to me. Okay, well, I want to see if it's gonna work this time. Let's see if it redirects y'all over here to this room, and it's just our verdict watch room. Let me see. I'm gonna make sure it's live first. Hey, Michelle. Okay, welcome in. So I'm gonna end this one, and we're gonna see if it drop y'all all off of where y'all need to be, because that's gonna be very awesome for me and us, right? So y'all don't have to be doing all that click clacking and clicking. Let me just in case it does not work. No, it didn't work, SD. SD, like, yeah, it worked. I didn't end the other stream yet, SD. SD already in the other room. No, that's not what I'm asking for. I want to see if I can move you guys. So everybody else just stay put. If you don't get moved, then this is going to be the link. But let's go ahead and try this. I'm going to end this one, and it should drop y'all off right where y'all need to be. Let's see. Okay.